My lord, I need to be traveling to sorry, my lord.
Please mention the original side mentionings now. When we take up the appellate side, we'll take up the appellate side mention.
The second half.
Second half, most probably. Unless this is finished earlier.
Yes.
Thank
Yes, sir. Also, yesterday I was mentioning this matter. Your lordship has passed an order on 21st of September.
What do you want now?
For today, it's item number 8 in the today's list. I think item number 8. Your lordship, it may be taken up at 1 p.m. because the
Then it is called on. Wanted a
no. It's already appearing in item number 8 in today's list.
eight. Yes. What do you want?
Your lordship, there are checks of occupational charges pending from the month of November. So kindly it may be taken. It cannot be submitted because there is a change in the account number. Your lordship has passed an order on 24th of September.
We'll do this. Please come back and mention at 1:10.
110.
10 past 1. Inform your other side. Mention it.
I'm mentioning upon notice.
Give a notice and at 10 past 1 we'll take up this matter. একটা 10 এটা call করে নেবেন. We'll stop the other matter and call this and pass that limited order.
My lord, may I please mention item number 22 of today's list?
Yes.
My lord, I'm praying for extension of interim order. My lord, the
When does
interim
it expire?
28th February, my lord.
We'll give a notice to the other side and we'll
Yes, my lord.
pick it up at 5 past 1. Yes.
Great, my lord.
5 minutes for you, 5 minutes for the other matter.
Yes, my lord.
তো একটা 5 তাহলে এটা দেবে। Call. Yes.
I had mentioned, my lord, on my mentioning, your lordship will kindly take my lord, the order of 17th December 2025.
Yes.
My lord, your lordship will recall, this is
No.
my lord, your lordship. My
For the appellate.
lord, your lordship, write a copy though.
Yes.
My lord, your lordship, this is my lord, execution of an award where my lord, the family properties which were in 4 parts, schedule 2, 3 and 4. Schedule 2 and 3 were being distributed by the between the two brothers, and there was a family arrangement.
Right.
Your lordship will see my lord, the second page of the order, my lord,
Yes.
which records, my lord, accordingly APOT 7 of 2024 along with GA 1 of are disposed of by directing the special officer who has been appointed to take immediate steps for registration of the deed of family arrangement in question, which has been circulated under cover of the letter of 29th April 2025. My lord, in this letter, my lord, by this letter, the family arrangement which had been circulated, we had only one objection which was there, my lord, with regard to the Schedule 4 property, which is not subject matter of the award. My lord, what had happened, I'll just show your lordship. So all I would request, my lord, the clarification or the correction that I'm asking.
To say, my lord, the appeal has been disposed of. It has to.
Let me just point it out after that, whatever your lordship takes. My lord, this is the what was circulated. My lord, if your lordship just takes, I'm just giving the page which has been circulated. My lord, page 16, your that subpara E. I need to do copy diyecho. Do copy dao. Well, I'm giving a second copy. My mistake, my lord. I should have given a second copy.
Yes. E.
My lord, E. Your lordship, the 4th schedule property. My lord, if your lordship takes, my lord, the paragraph, the award, my lord, middle of the paragraph, it records, my lord, the 4th schedule hereunder written to be continued to be held under Ramdas Mahadev Prasad HUF since dissolved. My lord, we are not agreeing that the HUF has been dissolved. So this one word, since dissolved, we had, in fact, my lord, in our letter which was previously exchanged, we had struck off that since dissolved. This has gone in, my lord. This since dissolved. That's
Mr.
the only
Mukherjee, we had just directed that the deed of family arrangement will be registered by the special officer. We have not expressed any comment on this.
My lord, only thing that the
Circulated, yes.
Circulated under cover of the letter.
But the direction which was given is by directing the special officer who has already been appointed to take immediate steps for registration of the deed of family arrangement in question.
Yes, my lord. There's no problem with that part.
That is the only direction given.
My lord, what has happened, which has been circulated under the cover of the letter. My lord, what I'll sequence of events. I'm sorry, my lord. What had happened in February, my lord, the February 2025, the special officer had circulated.
But this is a part of that deed of family arrangement.
Yes, my lord.
So if you had an objection, why didn't you tell at that
point? At that point of time, what had happened, my lord, this had come up and this letter was shown. The sequence of events, what happened, my lord, in February 2025, the special officer had circulated a draft family arrangement to the parties. Immediately, my lord, we had responded saying that this since dissolved should be deleted. The other side objected that the since dissolved should not be deleted. There was no consensus with regard to the since deleted. In the meantime, what had happened, the special officer had given this family arrangement to the stamp valuer, to the collector for stamp valuation
Mr.
for the
Mukherjee,
purpose
file a
of
one-page application,
one-page
two-page application. That will be better because Mr. Shen obviously is
Yes, my
objecting.
lord.
One or two-page application, just pointing out this. Whatever you're saying, just
Yes,
point
my
that out. Put it on oath and
But I would only like to I may not make any comment now. Let him file an application because the matter was taken up by your lordship in December only because there was a dispute regarding the
Mr. Shen
assessment of
will hear
stamp
you.
duty.
That's why you
Mr.
are asking them to file an application, a formal application. When they file that application, if you give a copy in advance and then mention so that Mr. Shen, you can come prepared with any objection if you have.
I'll do that immediately. I'll do
Yes,
that.
So please do that.
Well, this the fourth schedule is actually beyond the.
No, we understand.
family
Then that
arrangement.
might require an adjudication or at least
I'll come back with
Yes,
that.
it's a
but
substantive.
kindly do not give any indication of a one-page application. It has to be an application, whatever is
So
maintainable under the law.
3.5, 4.5.
Actually, a review will lie.
I will
No,
come back
if you
with
don't say one-page application, verbally at least it will be 10 page
I'll
because
come back with
then
an
the
appropriate
council won't have any control over that. It will go to someone else.
I'll come back with an appropriate application. Well,
Very. Learned counsel appearing for the respondents seeks modification stroke correction of the order dated December 17, 2025, passed in the matter. Full next para. However, learned senior counsel for the appellants opposes such modification stroke correction. Full accordingly, the respondents are given liberty to file a formal application supported by affidavit seeking the self-same modification stroke correction and serve an advance copy of the same to the learned advocate on record for the appellants. Full liberty to the parties to mention such application, as and when filed, for enlistment.
next Wednesday is will come back possibly the week after.
You in the meantime, you can file on Monday if somebody is available. File on Monday, give them a copy so that you can mention on Wednesday and we'll put it next.
Next Wednesday is a holiday. I think.
Oh,
Holy holiday. Tuesday, Wednesday, 2 days are holidays.
we'll have to wait.
We'll come back.
It return করব that return চলে গেলে return করব yes thank you. Yes,
Volume 23, please.
report এসছে কিসের report? There's a report by the registrar in charge. We'll just check up what is the report, Mr. Bose. Oh, as expeditious that order has been formally recorded.
No, no, your lordship has considered this order.
Yes,
and that is why your lordship.
This is a formal report by the registrar.
Volume 23. My lord, I was placing the judgment.
Yes, please.
My lord, I have already placed.
Sorry.
My lord, it's volume 23. The judgment starts at 3154.
Yes, Mr. Bose.
Now, my lord, from 3162, which I had pointed out already, my lord, is the my lord, the portion relating to the interlocutory application and the vacating, because GA Com 1 was the interlocutory and GA Com 2 is the vacating. My lord, I have already placed 3157, which is GA 4, which was the application, my lord, challenging this dispensation because there was no urgency. Remember, my lord, the pleading, we are carrying on business from 2021. My lord, and one of the grounds, my lord, is that at page para 13, which I have pointed out, my lord, yes, sorry, 3159, just two portions, I'm just reminding. My lord, in the middle, 3159, the petitioner alleges petitioner to have been unaware, my lord, it is the of the licenses granted to respondent number 1 by respondent numbers 2, 3, 4. Also alleges to be in the dark how was claiming registered proprietor of the impugned mark. My lord, this is with regard, so this is their allegation, and obviously, my lord, it was sustained. Uh, yes, and in the last portion of that very page, petitioner also alleges infringing products per se do not disclose any connection with the respondent number 4, because respondent number 4 is the registered owner. Yeah, and I've never said so. Miller, all the learned judge had to look at the applications, the various documents from 2015 which I have annexed, that the defendant number 2 is carrying on business. All that the learned judge had to look in the documents which I have annexed, my lord, showing from 2021, I am carrying on business with this particular mark. Continuous series, voluminous, pages numbers I will give you later on if you want. I can, my lord, I've checked from 2015 in the name of defendant number 2, because it was given to the defendant number 2 by defendant number 4. From 21, I got another letter from defendant number 4, use my mark, and my lord, the copyright which defendant number 2 was enjoying, my lord, given, my lord, roundabout that allowing me to use that, because they now I am using from 21 documents annexed, my lord. Now, my lord, then para 13, there is this finding, my lord, I said, my lord, it's a pleading that the defendant number 4 is a registered pleading mark holder. But what they annexed, my lord, is not gold stag. My lord, kindly see para 13. Petitioner has also annexed the filing of with the registry of extract of IGM gold ring instead of IGM gold stag. And the petitioner has disclosed the fact that respondent number 4 was enjoying both in the price. And inadvertent bond disclosure cannot be. Who is saying? That is what is he saying. My lord, he annexes. Now I come to, so on that ground, my lord, whatever, my lord, this was rejected. Now, my lord, 3162. Now, my lord, if your lordship wants to point which will go against me, my lord, appeal from rejection under this GA4 lies directly to the Supreme Court. I have not gone to the Supreme Court on this ground. I must say, therefore, my lord, a point may say, why didn't you challenge this? That goes to Supreme Court. But it's a common order, which is cited. And I should also tell your lordship, recently, very recently, there is one judgment which has come out that in these trademark matters, etc., basically, my lord, because of urgency, etc. But according to me, that doesn't take away the right. If you have knowledge of something going on, my lord, for a long time, then my lord, that is my submission. But that's neither here nor there. I have not filed a special leave petition against. My lord, I have, although, my lord, straight away I will come to the law. I will, because facts more or less I have pointed out after reading the portion of the judgment, which your lordship asked me to do first. I didn't. My lord, I needed to
get an idea of what to look for.
Yes, now your lordship knows basically.
Yes, you have placed the case.
Yes. My lord, 3162, my lord, please make a note. Upon filing ad interim order, my lord, the date of the order is 6th February 2025. Court granted ad interim order, also directed special officers to visit offices and file a report on the same day, ex parte order. My lord, this is, please note, John Doe, Ashok Kumar does not have an address. So the question remains, how did they get the address? That they will go here, they will go there. And my lord, I have pointed out from the interim order the places where they visited, all Nakuda, Punjab or something, railway station, Nakuda, all my lord, Jalandhar in Punjab. Why only there? Why not anywhere, my lord, in West Bengal. My lord, please make a note of this. This has bearing on the question of passing off, which I will argue later on, my lord. Because, my lord, under section 134C, my lord, of the Trademark Act, my lord, 134 is on infringement. My lord, C says the cause of action of infringement, the passing off, is completely different. My lord, completely different. Infringement is, my lord, one cause of action. For infringement, the statute has said that if you can sue anywhere you want. You can sue anywhere you want. The plaintiff, because you are infringing. My lord, I mean, no actual deception need be proved. It has a registered mark holder. You sue anywhere you want. But, my lord, 134 small c says that nothing will prevent passing off, from suing for passing off. The question is where? Now, take it independently from 134. Suppose it was a case of passing off only. A cause of action of passing off is completely different from cause of action of infringement. Suppose he wanted to sue for passing off. My lord, the only place he could sue is where the defendant or the cause of action arose. Cause of action, my lord, for passing off. My lord, please bear this in mind when I deal with clause 14. When a person says, I'm sorry, I'm indicating the points. I'll just rush through the points. When a person says, look here, I am carrying, he's carrying on business. I am carrying on business in Punjab. He has said he came to know from his offices in Punjab that he found out that I am doing this and these places. That's a pleading in the plaint, which I will show you. So admittedly, he carries on business in Punjab. Well, nothing to do, but it is important, which I'll tell you a lot why. I am carrying on business in Punjab, admittedly. Only in Punjab, because he mentions only in Punjab. My lord, the cause of action arises in Punjab and nowhere else. Now, it is possible under clause 14 of the latest patent, after the suit for infringement is held to be maintainable, you come and say, look here, I have caught the defendant. Why not also add a cause of passing off, which I could have filed or should have filed in Punjab with this. My lord, this is the ratio of clause 14. I'll come. There is an added thing which I want to tell your lordship now. Even infringement will have to be filed in Punjab. Your lordship said why? Because of a judgment. I will show, my lord. I am not saying he does not have jurisdiction, my lord, in anywhere in India, wherever he has place of business. 134 says so. He can file. But in a case where he says, I am also carrying on business, and the defendant carries on business, my lord, in Punjab, only Punjab court will have jurisdiction. That is my submission on the basis of a judgment, which I will show you.
Suppose before we proceed on this, we'll ask you one question for clarification. Now, suppose we are looking at order 2 of the Code of Civil Procedure.
Order 2.
Why we are saying, suppose the same set of facts give rise to 2 causes of action, 2 separate remedies are available.
Yes.
Of and infringement.
Right, my lord.
And as per order 2, you have to club the causes of action in the same suit. You cannot later on, unless you seek a leave.
No, you have to take a leave. My lord,
then you can.
because you, my lord, order to rule 2, because you cannot file a this passing off in this court. Therefore, grant me order to rule 2 that whenever I want to file criminal or other things like a passing off.
Not on that. If it's a composite cause of action for both infringement and passing off.
My lord, it is not. That's what I am saying.
That's
134C says, 134C, it's independent. No. No, it's an independent cause of action. My lord, that is why you ask for all matters, my lord. You ask for
Even if it arises from the same set of facts.
maybe, my lord, no, it can't arise
Chain
from
of-
set of,
chain-
my lord, it cannot arise from set of says. I'll show the difference between the two causes of action.
Suppose I'm selling the property,
My lord, you
infringing
can
of that
sell,
as well as passing.
but the tests are different. My lord, one is actual deception wherever you are there. This is a statute
All
has said 134. It's completely different, and that is why he knows it. It is completely different. Therefore, my lord, clause 14.
Aren't there common elements in
My lord may or may not have. That is why clause 14. That is why not. I could imagine this was falling from your lordship. That is, these are completely different. My lord, that's why I began by saying, why are you, my lord, your lordship should not even think about passing off. Imagine he is only filing for passing off. He has.
Okay.
My lord, it's a get up his side, whether he'll succeed or not. My lord, I'll independently address also, assuming you are against me, my lord, on all these points, I will independently address. That's a different issue, my lord. But the thing is, whether he'll succeed in Punjab also, I don't know. My lord, but the point which I am trying to make, the two are independently, he knows it. He knows it. Therefore, 14. Now, my lord, order 2, my lord, he did not. He can. He should have. He cannot file. He is passing off here. His pleading may say so. He took it for granted that the leave would be granted. My lord, that side. Obviously, I'm going to object, but your lordship may turn down the object after. No, I'm not your lordship.
No,
The court may turn down the it's a my lord, you are subjecting a person. Suppose it is in my lord, lordship is thinking about I mean, why India? It can be in England. You are suddenly bringing someone, my lord, here and clubbing it, and then you say, why will you object? Why will you object? I've already caught you.
Right.
With a good case.
No, you took a point also, Mr. Bose,
My lord,
that
show cause.
show cause was issued but not culminated in.
My lord, at the trial. My lord, remember trial? That is the significance of the word trial.
Yes.
Suppose a trial is yeah. My lord, why?
Yes, we get what.
My lord, trial. Why trial? Because you are so convinced that infringement, copyright will succeed in this court. Defendant, he is already, you've caught the defendant already. My lord, why should he? Why should you enable that the plaintiff to go everywhere? I mean, go to Punjab to catch him for this. That is when you exercise your discretion and grant leave under 14 at the trial. Because one trial will proceed. No crazy person may not say, no, for this trial you go there, for that trial you go there. May not, it's a convenience. May not, yes. Now, I am on a more fundamental point, which I will address a little later. Everyone knows in section 62 of the copyright, this is a statute has given protection to a person that if you have a registered mark, you did not go anywhere. You, wherever you are carrying on business, you file it. I only say one small rider. Yes. But if you are also carrying on business, if I am only in a particular place and you are also you are also at that place, then my lord, you should file it there. That is in Punjab.
There is an averment in their plaint that they are
Yes,
carrying on business only there which you placed on the last.
Well, not only there, they are carrying on business in Punjab.
Only in Punjab, not in Calcutta?
Oh, me?
They.
No, not they. If I am carrying on business only in Punjab and they are also carrying on business in Punjab, yes, well, they are carrying on business everywhere in India. In branch office, they have a branch office, full.
Sorry, yes, you.
Yes.
The other way around. Just reverse it.
No one briefs me in this for big companies. And that too, I was not there in the trial court. I told you, Lordship, the entire set, none of us were there.
You have castigated whoever was there sufficiently. In
No,
every
I have not castigated. My lord, whatever the clients.
Remind me as that you were not there and they were not.
No, my lord, I said because I may the facts. Some of the facts I
Not have said that. It's just in jest.
my lord.
Forget that casual.
Oh, no, my lord.
You are castigating no one.
People who are there, they are
Apart from
great
the other
friends,
side, you castigate.
friends of mine in the profession.
Yes.
Great friends of mine in the profession. Now, if your lordship really wants to know, this client was roaming about and wanted suddenly the advocate record is wanted to brief me. I said no. I mean, halfway someone is addressing, I won't. Maybe. And then in the appeal court also initially I was not there. They took a change and because something happened with another set which was happened. So, that is the story. Then I came in and I said I need a junior. I told you brief Mr. Shomo will help me. And he, in fact, half what I was saying, it is his work. Mainly. So I very little contribution as such from me. My lord. Now, my lord, so yes, file report which are taken on record. Now, my lord, in the order, my lord, this is the rival packaging.
Yes.
Here, my lord, the question is of my idea is basically passing off in the mind. The rival packaging, petitioner impugned products are being shown. Now, my lord, I have already shown the product itself, 85% is this. My lord, please look at the two products as which is in the mind of the court and comparison is being made. Why comparison, my lord? If I may say so, with respect, because passing off is being argued suddenly. My lord, and the last portion is the best. Roundel device. Roundel, we found out, my lord.
Last question, yes. Like
medallion.
medallion.
Medallion, my lord. These medallions, my lord, which are...
Disc and medallion, these words were found out from
yes,
Google search.
something. Medallion.
Both,
So your
yes.
lordship knows the shape, my lord, basically oval shaped thing, medallion, which is there. So, and you will not find, my lord, medallion anywhere. My lord, I will not address, just pointing out that it is the shape and sorry, combination was there at the time of passing of the order, and the comparison apparently was being made by my lord, learned judge.
So ideally, the first front panel should have been overlooked altogether.
My lord,
And the other panels,
the other, no, roundel device.
No, overlooked in the sense that should not be looked at all.
No, my lord, since your lordship...
The others are looked at, then there is no similarity, you may say.
My lord, another thing, the cigarette stick is being shown.
Because
now,
the stamp is also given on the stick.
Yes. Now, my lord, my lord, I did not say this, but my junior said, yes, you also argue this. My lord, these are sort of there is a prohibition in advertisement. Cigarettes, these loose thing, you will not go, you order online, you order anywhere, you will get it only in packets. There is a packaging. Yes. And my lord, although I haven't found loose cigarettes as such, cannot be. It's always in a packet these days. Therefore, the packaging rules have come. My lord,
there's the element of Article 47 also, directive principle, which says that intoxicants and all these things, the state's duty is to prohibit them and discourage them. So that is also taken into consideration when these rules are framed. We are dealing with in a different matter regarding this liquor business.
My lord,
but they found it.
My lord Parnod, I will show last this judgment. Same thing. Whiskey and Milan bottles, it's not advertised. You can't. That is taken into account, my lord, in the Supreme Court judgment.
So it's res commercium extra.
Correct.
That's the term used.
Yes.
You cannot claim it's not justiciable under Article 19(1)(g). because you cannot claim a right in carrying on a business in intoxicants.
Yes,
That's the premise, underlying premise of these prohibitions.
yes, and of the prohibition. So I said you can't advertise openly.
Yes.
Therefore, you can't
So therefore,
take out.
rely on the cigarette sticks, you are saying.
Yes. So if someone is doing this, small, give me one.
He has to buy it and then open the packet and then look at the cigarettes.
My lord,
So you cannot say that it's passing
if a biriwala is illegally doing it, you will not put a stamp to something he's going.
Biris don't have stamps also.
No, a biriwala, pan a local in the village, my lord, poor people said, just give me one. And my lord,
This cannot be done with cigarettes.
it cannot be done. If someone is doing it illegally, my lord, your lordship will not take notice of
No,
that.
cannot.
Yes,
Illegal.
that's what I am saying, my lord.
Yes.
So why are you showing this cigarette stick?
All right.
My lord, when I deal with passing off, I will elaborate on this, provided your lordship will at all entertain this plea of passing off. That will be my first submission, my lord. Kindly, my lord, after these sections, I won't, my lord, point out, my lord, section, my lord, 17. But since your lordship wants these are taken into account, my lord, it basically sections are on the point that if there are two rival, my lord, two rival marks, that I am registered, you try, no one can claim exclusivity of that mark. So both are there together. And coupled with this, my lord, you cannot dissect a particular mark. Here, if you have said, my lord, gold is gone, is disclaimed, my lord, then it is a case, my lord, of what you call historical estoppel. What is historical estoppel? That in one forum you are saying it is disclaimed. Now in this forum you say I have exclusive mark over the right over the word gold. No, you can't do that. That is apart from the story of approbate, reprobate. My lord, in one forum, therefore I will cite some cases, my lord, that if you carried all the weight, I think, to Supreme Court also, that this is a question of a estoppel. In one forum, you are saying for one purpose this, and then you are not entitled to any order on that. My lord, and the entire plaint proceeds as if, my lord, I've shown you, my lord, you said, why are you, they are claiming right over the word gold, because by usage, gold has become. Firstly, apart from that, it cannot become gold, and gold means a brand. Gold, my lord, gold.
It's a generic term also. Gold is
No,
a metal.
gold, 555 gold. Everyone has a gold. This premium gold.
Strength of the cigarette. Medium, red packaging is strong cigarettes, white packaging is light cigarette, and gold packaging is medium strong cigarettes. That is why
You should have a proper conference by having a taste of these things. Otherwise, you won't know what you are arguing about.
I don't know.
It's dry law.
They're dry and all
Smoke
that.
is also dry. Not that smoke is very liquid. So, Mr. Bose, you were saying gold is taken away, it's tag versus flake, which have no.
Right, now that's a question.
Very obvious.
That is one question.
Very
Passing off, right?
Yes.
I will address later. So let me quickly finish the
Uninteresting trademark part.
I have told you what it's all in the section. If you want, I will give you the section. My lord, the relevant sections are, I think, section 17, subsection 2. I think, my lord, our relevant sections are 17.2 and 28.3.
All right.
I think so, my lord.
Yes.
Yes, I'm right, my lord.
Yes, we can see that from
28.2 and 28.3. These are the main. I have also written many other sections, but I think they are wholly irrelevant because it's no, my lord, to show that when you are registered, what you are claiming? You are claiming exclusivity over that mark, my lord, and these are the things if two people are. So, my lord, over there. Now, my lord, para 17, 3165.
Yes.
It is true that section 17 of Trademark Act 1999 confer exclusive rights on the register to use as a whole and not in parts, particularly when parts are non-purely descriptive. Now, I'm not pausing here for a moment. If a person says that the gold is disclaimed, so what I want to know, have you got a registration for flake only? If you have for flake, then you are debating whether flake versus tag. Milord, then Milord 3166, Milord, second line. Thus, any assertion of exclusivity over elements of a compound, unless supported by not common to the trade and independent, cannot sustain a claim for statutory infringement. Finding, clear finding of learned judge, and correct finding, my lord, I will say. My lord, as a general principle, laudatory expressions as super, best, gold, or ultra are often used to praise and describe quality are considered non-descriptive common. Courts have held that such words, when forming part of, do not per se confer any exclusivity proprietary on a party. Then, my lord, thus in cases where descriptive registration does not grant exclusivity over those elements alone under section 2B. My lord, what I have said. 19. Indisputably, repeated journal suggests that word gold has been found to be prominent feature, also enjoying distinct, but does this fact per se give monopoly on the word gold? The answer is no. My lord, then, my lord, para 20 in the middle. It is also true, my lord, this thing of mine. There is a disclaimer in some registrations. My lord, it is enough in one registration. If you have given, my lord, I told you the historical estoppel, my lord, which I will cite. I mean, you in one thing you are saying this, in one you are doing this. Now, my lord, in some, but does the ultimate consumer have knowledge of the same? My lord, how is it? Does the ultimate consumer have knowledge of the same? You are talking about infringement. Though petitioner has no registration, where proceedings are pending, fact that trial rivals have a deliberate calculate. This, my lord, this is a this is a observation, but not sustained. My lord, 3168. It is true that evidence relied on by respondent number 1 suggests there is some use of the word gold. Nevertheless, it may be sufficient to be described, insufficient to be described as common to the trade. These are findings. Doesn't then in the middle, some of packages relied were merely depicted. There is available in the market. Fine. Little down. On the other hand, this is in my favor. On the other hand, though under the law there can be only one mark, one source, or one proprietor, there are a multitude of registrations for gold formatives in class 34, which cannot be disregarded. So, my lord takes into account there are other registrations.
Sir, Bose, what is class 34?
Class 34 is the cigarette thing.
That category.
Tobacco key. That's the 34.
The category which covers cigarettes.
Yes. In addition, the respondent is enjoying registration bearing such and such registration number. Fine. Therefore, prima facie, keeping the competing rights of the parties, petitioner's case of based exclusively and having secondary meaning is found to be annexed will have to be await trial. My lord, what will it happen? My lord, therefore, learned judge modifies the orders. My lord, remember, prayer A had been given. My lord, it is modified to prayer. I think one is certain prayers. The modified prayers also contain this infringement. My lord, that is, my lord, while reading all these.
Apparently, the intention was to deal
Correct.
only with the passing off.
My lord, I should also indicate there is, after we file this appeal, there is a, there also cross appeal. They have filed.
Acha, regarding that.
So, my lord, I don't know, my lord, we are only on the interim order. So, my lord, but it is awaiting trial. Now, my lord, learned judge wants to say in the preceding paragraphs that look here, but it may be in some cases, although this, it has an overall thing you have acquired, but it has to await trial. Because the previous paragraphs I showed you, lordship.
Yes.
So it will have to await trial. Now, my lord, so this is the end of infringement. Learned judge finds there is no infringement. According to me, it will await trial. Paragraph 22 onwards is passing off.
Yes.
On the other hand, registration of a device or label entitles proprietor to protection against its unauthorized use by a rival when such use involves identical or deceptively similar taste inside is to be the eye. Classical thing of passing off. My lord, use. I must use. In passing off, you must use it. Therefore, where the defendant is using in infringement, doesn't need that you have a registered mark. My lord, that's the small distinction between passing off, my lord, and I drew a contact to I page number. A bare examination of the impugned packaging would demonstrate there are striking similarity resemblance between the two. In the two products, the word gold flake and gold stack are written in black. Now, my lord, I will only read the judgment and then make my comments about this comparison. You have it, my lord, whatever is there, because apparently learned judge has set it out in the my lord, judgment, the packaging. Trademarks, gold stack and gold flake are cased in a device. My lord, roundel, my lord, this is probably saying in a device. The color red has been used for the devices in respect of both marks. Both products contain gold. Now, one by one, my lord, contain gold. Of course, it contains gold. Now, my lord, infringement disclaimer, my lord, has not succeeded. My lord, black and red color combination. Packet gulo ache. Color combination. In conclusion,
Give us only empty packets, please. Yes.
now even these are from.
We want to be very objective while considering this.
No, no.
So that's why we
those
don't want to
packets-
have any filled packets.
No, those packets by this time, my lord,
Might have become half empty.
no, not half empty.
Half empty or half full, that's the question.
Still,
Please, Mr. You confine yourself to law.
it's
Please.
not still. Oh,
Don't comment on the product. Tail, cigarettes and all these things, please. Unless it's damp.
isn't there an expiry date?
না sir, expiry date হয়
That
না।
expiry
লিখে
date is
গেছে
of the
ওটা-
consumer, not the product. So, confine yourself to law. We are hearing you are an authority on law, not on these things, please.
Who says I'm authority in law?
That is our perception, maybe wrong,
No, no.
maybe wrong.
My
But the other
yes,
perception we are
my
sure
lord,
is
my
correct.
lord, now see, my lord,
দিয়ে দিচ্ছি, আমি দিয়ে দিচ্ছি স্যার।
দাঁড়াও, ও দুটো দিতে হবে। My lord, let us
Let us have the packets in your.
read this and read whatever your lordship wants to cite has been noted by the because
Give us these things. Which you are holding.
I won't go back to this what the recording
Did not.
because this is
You are shown there.
yes
No.
এটা আরেকটা
হ্যাঁ এই তো দিচ্ছি।
দুটো পাশাপাশি করে দেন
দেখেছি আগে।
My lord,
ঠিক আছে।
না এইটা কেন? এটা তো gold stag. Now, my lord,
Yes.
so far as I can see, the color one is yellow and the other is
Oranges.
the gold.
Your the choice of your color, Mr. Bose, shows that the target group probably is different.
Hmm.
It's very
My lord, now, my lord,
target group is different. This
Now,
color would appeal to a different target group.
my lord, when I
See, their color and your color.
price is mentioned there. My lord, one is 50, the other is 100.
Yes.
95.
95. Na?
Whatever, yes.
Huh? Thank you.
Yes, yes. 95.
My lord, when I deal with Pernod and this, confusion is impossible.
Hmm.
It is, my lord, in Pernod, it was held, these type of things are had by elite people. Elite people don't make a mistake. I say it in a different.
Not exactly elite for your product.
No, I'm not saying. I'm not saying here the same analogy. But the fact remains.
So you're right.
Yes.
Specific, I mean, the consumer is very choosy on these things. They have their brands and-
That is one aspect. You ask for a gold check. I am saying, when you get how much? 50 rupees.
Acha. That
50
conspicuous consumption sort of Veblen
What
effect.
what are you giving?
Veblen effect in economics.
Of course, minute. 95 and 50, half. Half.
Yes, yes.
Addiction, sir.
No. That is, addiction is something.
No,
That is a separate
the
issue.
two aspects, Mr. Bose is segregating the two aspects.
Now, my lord, in this side, gold stack are what is encased in a device. I don't know.
Encased, sir.
Huh?
Encased in the device inside.
Encased.
Oh, encased. Oh, I see. Acha.
Encased in a device.
Encased in a device. Well, roundel, I don't know. Color red has been used for both marks. দেখা তো আরেকবার আমাকে দেখা। I should not do this test minutely compare. That is not the test.
আপনারও মনে হচ্ছে তো? আমি তো জানি না।
তুই আমাকে দেখি
কি দেবো?
ওইখানে
কালো হচ্ছে যে
এই device
আরে না অন্যটা দে, সিগারেটটা দে, ওদেরটা।
হ্যাঁ, শুধু এইটুকুনি দেখছি আমি। এইটুকু। Exactly.
My lord,
Apparently কোনো chance নেই। Yes.
my lord, where is the red inside gold stack?
Hmm.
Yes, it is written in black.
Hmm.
I will, obviously it's a color thing. I will write it in black. Millard,
No, the banner sort of thing behind your name, that is also in red.
এইটা
So the shape is different. Theirs is a roundel, yours is a sort of this-
roundel I understand.
No, yours is a banner sort of thing.
Yes.
A banner sort of thing.
rectangular
No, what I'm saying, where is the red?
No, red is there. Gold stag, that's
Yes.
embedded in a sort of background.
The red is there. Combination is there. But it's, you see,
There's no roundel.
the roundel is red. And in between gold flake. What I am doing is not the test.
No.
That minutely you will look at
No,
this.
understood. Understood.
You can hardly see my red. Please forget
প্যাকেট ফর্মে দিয়ে দিছে
forget the top portion. 85%. You should only look at this.
I'm accustomed to forgetting the top portion.
Very dangerous. I mean, that's good. I mean, for
Yes. Yes, Mr. Bose, you are very clear.
Yeah.
We understand. what
no
you say.
and red.
No roundel.
And
Red
what
is.
I have mentioned.
Yes.
So, Milord, it says in conclusion, Milord, infringing products thus depict strikingly essential resemblance in their get-up, layout, color combination in such. Now, Milord, this is one paragraph. This is one paragraph on passing up.
Yes. But the learned judge was absolutely objective, we must say.
Milord, this is the case in the petition.
If he could come to this finding, he was absolutely objective.
Milord, this is the case in the petition.
Yes.
Milord, para 23 is, I say,
Yes.
is the only, then after that, entire discussion is on passing off.
Passing off.
Milord, 23 is the only, Milord, paragraph
Copyright.
on copyright. Milord, copyright, Milord, Milord, Usually, my lord, I not understood. It is actually
It's a work of
books,
art.
books. Huh?
Work of
My
art.
lord, people use it also in trademark when you have infringement and trademark. Why should you go to all this artistic design? And artistic design from 1905. That is a pleading in the plaint. Why should you go to artistic design? You have a wonderful case on infringement. You have a wonderful case. No one. But people say this because that's a cause of action. It is also. So, my lord, it is an artistic design. My lord, copyright as such is for protect authors, people who write music, composers on this. But yes, our statute also recognizes this on this copyright. My lord, that is the law. I cannot go, my lord, and it is also parallel section like 62. In fact, parallel section of 62 is to protect the poor author. The author will sue whenever he wants for infringement of copyright. My lord, this is because this is passing off. These are different causes of action. You can't do it for design or patent. For that, different statutes are there.
Yet the artistic work is not German actually,
My
or
lord,
the product concept.
my lord,
That may
my
be.
lord, I don't. I will have a different argument. Then it is for your lordship to decide what artistic work. What artistic work is being infringed.
Vis-a-vis the product, it may not be relevant also. This artist, art in the
My lord, half of the artistic work is my lord, statutory artistic work. My lord,
yes.
no. My lord, about expiry of they don't have a copyright, etc. on the artistic, that I will make submission when I deal with, in fact, Mr. There are a number of.
You're making submission on all of the topics, and then you are saying when I'll argue on this, I'll.
No. I have to
Your
show the
arguments and
case law on this. Because if you are, since you are on this, my lord, let me read it and say why it is wrong. Then I will go straight to the law, my lord, after
Yes,
this. Yes. The copyright registration relied upon by the respondent are also invalid. Why? Contrary to Copyright Act, the year of the first publication is alleged to be 2013. Mandatory graphical warning will come into effect on 1st April. There is no certificate produced by respondent number 1 mandated under Rule 76 of the copyright rules. Pausing here for a moment. What is 76? My lord, if you want to register a copyright, you must get a certificate from the trademark registry that there is no mark which is infringing, which is similar to the trademark. You must get a certificate. May not ask to myself, you are pointing out these things. There is some rule. Where is your certificate? You have not annexed any certificate. My lord. Goose, gander. My lord.
And sauce.
And sauce. My lord. So, my lord, where is your certificate? I will annex. You have not annexed any certificate, but you suddenly have a copyright and say that you have not. Where is your certificate? My lord, I may be a most wicked person, but the law must be followed. There is no certificate. There are serious infirmities in the license from the respondent number 2 to respondent number 1. So, big holes. My lord, I will be saying this, whether there is a copyright infringement or not. My lord, that your lordship will first see, but you say something about rules. First produce your rule. This is number 1. And my lord, there should be some agreement in writing of assignment, etc. And you have not produced. Although, my lord, there is a retrospective thing which was there saying that copyright was assigned by defendant number 2, who is the user of the copyright, neither here nor there, my lord. Yes. Then says the Impugned mark is a slavish imitation and a crude copy of the dominant theme underlying the pen constitutes infringement. Original artistic work. What original? From 1905, which you have pleaded in the plaint. Gone. May not after 50 years, which I will show, may not, a little later. Is entitled to protect. The long extent of unique color combination has become site. It constitutes trade dress infringement under 2C. May not certainly.
No, their mark, this product is in bold, in block letters. Yours is not. And
Well,
secondly, the font is also different.
My lord,
Font is also.
my lord, artist, we are on artist.
No, if you are on artistic work, let us proceed on artistic work, because we are saying this for the other side also. They'll have to meet this, because theirs is entirely in block letters, capital letters, and yours is not, which creates a difference in impression also. And the font is also different. You can see that. If you see the G, you will find that the letter, the style of letter, which is a font, that is different.
But to be, it says unique color combination. What is the, I mean, when a unique color combination, I showed you, Lordship, the color combination.
Really?
Miller, oh, I understand. Probably they say it's black, yellow, or black, gold, and red. Therefore, this combination cannot be used by anyone. But I cite.
Very.
Then, Miller. Finished. Copyright infringement is finished. Mela, there is not a single more paragraph on this copyright. As stated before, herein before, this combined action for infringement, copyright, and passing off. To this extent, the decision that a suit registered against register is not maintainable is inapplicable. My lord, suit is maintainable under the Copyright Act. Suit is not maintainable, I say this, is not maintainable for passing off in this court, this High Court. There is no absolute bar in filing suit infringement against a registered proprietor. Yes, you can file, because the law says you can file. If you are a prior user, you can file. But yes, if you are a prior user, you can file. But my lord, if you are a registered trial owner, I am also registered, you cannot file. You cannot file because, my lord, I will show you one judgment. And this is what the learned judge has also held. In any event, a suit for passing off being common law is always maintainable, even against registered proprietor. Of course, it is. If you are a prior user, that's what I said. You can even file against on the ground of passing off. May not file it, but don't file it here. A perusal of impunity as a whole would suggest there is every likelihood of possible deception, confusion from the similarity of two products. Taste remains court's perception of a degree of resemblance between the marks in this context. Price variation does not aid. Why? This is contrary to Pernod. This. All these things, 85%, has nothing taken into account. Now, my lord, 25.
It was not also argued specifically by you.
It's all there. My lord, vacating an opposition is there. My lord, I cannot say, my lord, whether, my lord, if learned judge did not accept and considered and did not accept, that's one issue, my lord. Your lordship should not sit in appeal over that finding. There are now recent judgments also that does not.
Particularly intra-court, yes.
Intra-court, my lord, now. In view of the above, there are sufficient materials at this stage to conclude how is it relevant? My lord, are you attacking the real purpose is to get the number 2 to these people? Malad says number 3 is a criminal. That's in the evading tax. He's an individual. All these prima facie respondents are acting in concert, acts mask of the remaining. The alleged licensing invalid afterthought. Malad, I then says there is no written agreement for the period April 21-29. Who says so? There's no, all invoices annexed, nothing considered. In addition, invoices relied on predate the license agreement. Very well, they predate from 21. I've annexed so many invoices. No other responded, and these are with tax invoices. GST, everything I've been filing 21.
This investigative, incisive thing is probably also a copyright violation of your friend, Justice Banerjee.
Why?
Justice Banerjee,
You said-
look through the facade and find out those.
Manoj,
That's it.
Manoj,
You're
the
bound by the
corridor humor is, Manoj, since your lordship say that, if I may, with your leave, your lordship also has that. If you smell fraud, then
bias.
then
We find out a way to.
then
We find out the
you
law.
will not. That's a corridor humor. I said, so get a course where if you have a case says has been wronged, then that's one, and if it's criticized severely for doing all this, Lord Denning. It's always wrong. Always wrong. Because he, poor man's, yes, not Indians, by the way. Completely. You'll find all favor of Indian versus, right? It'll all go in favor of the foreigner. Anyway, no, all judgments. But he was an equity lawyer, didn't look at the law. Can I digress for 1 minute?
You require permission for that?
No.
We have not come down to that.
No. My lord, you must be knowing basic and basic. Basic and basic is basic and basic is specific relief act. My lord, whether a third party can sue for specific performance. That's the exception. My lord, it's a tradition is basic. So, my lord, the opening lines are: old Peter Basic was a coal miner. He was a good man. He was a poor man. My lord, these are the words. My lord, he had come to university, Cambridge, and he had been elevated to House of Lords. He said, I don't want to, I'll come down to Court of Appeal. So he said, why did you do such a thing from House of Lords? You see, when I was in the House of Lords, I had to convince 4 people. Now I have to convince only 2. Now, Millard. Now, Millard, yes. No other respondent has come before, and the respondent has attempted to make on their behalf, for which no one. It is obvious remaining are waiting in the wings for ulterior. How? Millard, prima facie, dishonest malafide respondent 1 to is written in the backdrop of the case of trafficking would require further at the trial. My lord, others may be bad, I may be also bad. But if someone does not, and not carrying on business, now, my lord, there is also no merit. Now, my lord, service, remember, it was 6th February 2025. There is also no merit in the content order has not been complied with. In matters of such nature, it is common for a court to extend period of compliance when appointing special officer to carrying on search seizure for preservation of evidence in order to obviate any disappearance by the respondents. The intention behind is for service to be effected after thorough such. My lord, what is this? You take him after 1 month. My lord, it is like saying that you get an order, appointment side, and you then go, see, I have this order. This is exactly what you should not do under Order 39 Rule 3. My lord, the intention behind such is for service to be effected after conducting such Caesar. Very well, why didn't you take him immediately? To all these 4 special officers roaming about, my lord, the entire Punjab, going to places where nothing, I told your lordship, only in one place. My lord, which is
Anton Pillar ingredient was being.
my lord, yes, but is there a law, my lord,
does
that
not
because
39.3.
because can you evade this
No.
requirement?
39.3 is not governed by Anton
No,
Pillar.
no, you take, of course. May not raid anyone, my premises, anyone's premises. By John Doe is there, na? May not John Doe Ashok Kumar. Now, my lord, special officer had served. My lord, this is important. On 28th February 25. So, special officer will serve. When special visited the premise in terms, petitioner had also served the respondent number 1 by post when? First, 6th February. And the same was received on 5th. My lord, immediately we filed a vacating. There has to be an inbuilt element executing, which are essential. Thus, courts do permit deferred service. Not all courts. Acknowledging the object of justice would be defeated if respondent is given advance notice. The procedural safeguard ensures are not 4-1, thus you are already get an ex parte order. In view of the above, there has been sufficient compliance of Order 39 Rule 3. There is no merit in the objection.
But probably if 39.3 is not complied with, you can get a vacating of the order also.
We had filed
You'll
that.
just-
We had filed
Yes, on that ground,
On that.
apart from other grounds.
apart from other ground.
39.3 non-compliance itself probably furnishes a ground.
That is enough. My lord, you point out, you need not go on filing application.
No,
On the returnable date, my lord, I was not
But-
served. Go, order goes.
yes.
I mean, that is to be the, not, not in original side at times. People didn't know. Always neglected. And people may not, in hire purchase matters, people are getting these orders and bargaining with, see, I will do this.
Because you have put it in the statute, Mr. Bose, that in Commercial Courts Act, that the judge should know commercial law, need not know the civil law.
Now, my lord, now,
It's in your statute. You are taking advantage of the statute day in and
my
day out.
statute,
Yes, yes. You thrive on that statute.
no, now no one thrives. Now, my lord,
So it needs to have a commercial knowledge, but no civil knowledge. You know commerce, know your commerce, and anyway, let us forget those things. Sensitive issues.
now, yes.
Yeah.
Now, my lord, in lower court also, orders, either people are scared or they are too bold. That is also bad, no?
Mirror image. On one side too bold, on the other too meek.
Yes. So what? If you are,
Potent
if
combination.
you don't, then you come, you have had it. You never get an order.
Yes.
Because you have to find 37, sorry, not 37. I mean, coming up in appeal, etc., etc.
Yes.
I mean, it's gone. Basically gone. The agency is gone. So you pass an order. And next party and all, and you're scared something will happen, that I will be, then you don't, then serve notice. No, ex parte, hardly. And if you're too bold, then pass ex parte. And then it never gets vacated. My lord, kindly see in the middle, for this is allowed. My lord, this order I showed your lordship the other day. A is gone. B is introduced along with many other prayers, and it says ad interim order read with stands modified. My lord, why modified? If I may ask, because infringement is gone.
C contains A.
Also B.
B also contains infringement. Second part of it.
Yes.
First part.
Yes, my lord, your lordship made a
You
note.
placed that.
I
yes,
placed it. I am
you've
not
taken note of.
I am yes. Now, my lord, the law. My lord, I will try to go very fast, my lord, and I've indicated the paragraphs I will show you. My lord, on the factual aspect regarding the disclaimer, my lord, disclaimer. There are 4 disclaimers in respect of 4 registrations.
Gold.
Yes, 4 disclaimers.
Hmm.
Now, 3 of them registrations have not been annexed to the plaint mentioned in the plaint. Only 1 has been mentioned. My lord, remember some objector I checked up, my lord, that said you should have also shown this letter, my lord. My lord, in respect of 1 which has been mentioned in the plaint, my lord, page 592, it was date of application. This is mentioned in the plaint. Date of application is April 2024, granted on 17th February 2007.
17th February?
2007. I'm saying something in their favor. 17th February 2007. My lord, that in my vacating application, on the ground of suppression, many grounds there are many disclaimers. I annexed the disclaimer that you should have also said this in the status shows it is disclaimed. The gold is disclaimed. That is at page, my lord, 2357. Right? 23, just check me. Then what is 2422?
2422 is their letter to the.
Thank you, yes. So, my lord, this status continued for a long time. Then, my lord, suddenly, after 13 years, in 2020, they apparently wrote a letter to the registry saying, why is it appearing? It's wrongly mentioned, but because when you advertised, he's saying in 2007, the disclaimer portion was not advertised. This is so they raised objection. So it is wrongly. Please rectify. The status in 2020. This letter is there, and as on date also, the status still remains.
So that was not acted upon by the authority.
My lord,
not...
well, my lord, no, not acted upon. Now you can ask me, so what should they do if something wrong is happening? If wrong is happening, my lord?
My lord, just to point out, it was acted upon and the status was corrected.
Status has been corrected.
Corrected?
That is on record somewhere.
It has not been placed on
Not
record.
on record, Your Lordship.
Yes. So, my lord, that is, it was not point.
But then it must be post fact to the order, after the order.
Yes,
My lord,
yes,
it's subsequent to.
Oh,
So then we probably...
my lord, I mean, that's
We
not
are
the.
testing
My
the
lord,
order
please hold whatever it is.
We'll take a note of that.
Yes,
That it's
my
after the order.
my
So
lord, please.
fair enough. Yes.
My lord, please. Sir, I'm just telling you the facts, my lord.
No, we understand.
Now,
Please.
there are 3 more disclaimers, which all disclaiming gold.
This letter of 2020 was pertaining to only 1.
One. I told you the one which is referred to in the plaint.
Acha.
My lord, I told you at 592.
Yes.
Yes, and I told you that my lord.
2357. You
Yes,
pointed
yes,
out the
my lord,
others.
my lord, this is it. Now, my lord, there is no answer to gold flake device status per se, where also disclaimer appears. Page 2383. Another registration. My lord, this registration is gold flake device with a disclaimer of gold. Page 2383. No such letter anywhere. Here, advertisement with disclaimer. My lord, label gold flake. Status, page 2385. So I've given you two. Disclaimer. Now, my lord, gold flake silk cut device registration. আমাকে 2387 device. Oh,
label device.
अरे भाई label device तो हमका device
Device or
ना
Label can be a device.
label?
Oh, label
Label is a device.
label as a device. My lord. He's saying no, it's label.
Label.
Yeah.
Gold flake silk cut is label.
Yes,
Right.
it's written label.
What is the page number of that?
My lord, it is 2387.
All right.
Kind of mark is device already.
Oh,
It can
oh,
be a label.
my lord,
then
but it is written, he's right. It is written trademark to be, it's also a device. Probably the label is being is treated as a device, as would appear from this statement. My lord, here also disclaimer. Page 2387. হ্যাঁ তুই যা দেখা
That was the first question we put to him.
Vested interest.
He was arguing, we couldn't believe our ears. He argued that these cigarettes become stale after a point. We said damp, not stale.
He would not know these things.
These subtleties are not beyond him.
I would have understood if it was things like perfumed hair oil. He's a connoisseur of such things.
Yes. Hair oil, my lord, but nothing is working. Hair oil, my lord, I spend a lot of money. But nothing is working.
The previous Chief Justice would be very happy. Our previous Chief, because actually he told me we had a talk on this hair oil and all.
Must have been coconut only, pure.
Yes. Yes.
Pure
Yes.
He does not believe in coconut, anything pure.
Yes, Mr. Bose.
Yes.
Please let us continue with the disclaimers.
Yes. So, my lord,
We start with a disclaimer on this.
3 disclaimer existing on record, present status,
Yes.
disclaiming gold.
Hmm.
They were advertised, obviously, with in the opposition, in the reply to, they say about this only, out of the 4. Out of the 4, only 1 they have said I have written, and now they say I take it, my lord. It is.
You pointed out all these 4 in your vacating.
It's there on record. Yeah, otherwise it wouldn't be the page numbers, my lord. Now, my lord, on the basis of this, I cite some judgments. Yes. My lord, the first case is Sulochana Bai, my lord. On Sulochana Bai, which is there, my lord,
Page 295.
at no, you're giving compilation.
Compilation is already given.
My lord, some of the judgments are not relevant.
Pick off the.
Yes, but you can, my lord,
Solution.
এখানে আমার মার্ক করা আছে, my lord. হ্যাঁ,
আপনার copy, second one. দেখুন,
এটা কি সুলোচনা ভাই এখানে আছে? My lord, it is probably in that compilation at page
295.
295. My lord,
Yes.
para 11. According to the High Court, at page 304, madam. Sorry, the case reporting is
Yes, 2016 2 SCC 683.
2016 2 SCC 683.
Yes.
My lord, para 11, according to High Court, respondent is not only a prior user of the trademark, she has even prior registration of trademark, whatever that is, halwa, as she got it registered on 17/8/2007. Insofar as the appellant is concerned, he got the trademark, another halwa, registered on such and such date. So, 2 registrations. My lord, para 17. No doubt, respondent claims prior user of the trademark, this halwa. Moreover, she is also registered owner of this trademark, which she got registered in 2007. This registration is even prior to registration trademark of the appellant. My lord, then very. But at the same time, we have the appellant who is also a registered owner of the trademark halwa, which was registered by Ray in 2008. In fact, situation when the appellant also has trademark duly registered in his favor under section, what are the implications thereof in question? To put it otherwise, what are the rights of registered trademark against other who holds valid office, which is the moot question. Like ours. The point is, whenever you are registered, it's a long drawn process. You have to advertise in trademark journal. It is to the open and people are conscious what is being registered. If you allow it to exist, then the question, that is the principle. Paragraph 20. Procedure for registration of trademark provided section. When such application is accepted, registry is supposed to advertise the same. As I was telling your lordship, the purpose of advertising is to afford public at large opportunity to oppose the registration. After such a right, registration convert to every public as a person can file objection. The opposition is to be made. Such once opposition, registry is to serve to the applicant within 2 months, etc. In case does not file, it is deemed he has abandoned his application. So, my lord, a little below last few lines. Once application is accepted and either there is no opposition thereto within such object, if filed, are decided in favor, register shall register the mark within 80 months from such and such. Then, my lord, next page. Section 23 mandates that such registration and further provides the trademark when registered shall be registered on the date of making of the application, shall be subject to one, shall be deemed to be the date of registration. It goes back. My lord. Then, my lord, little below. Thereafter, section 25 duration, removal, restoration, duration of trademark as per 25(1) is 10 years, which can be renewed for another period of 10 years from the original. Subsection 2 thereof permits renewal registration for further from date of expiration. If duration has lapsed, applicant does not steps renew, then enables to remove the mark. From the aforesaid procedure contained, 2 things are apparent, which are recapitulated as under. When application is received and accepted, public notice, they talk about this, 22(2), while considering such application, would amongst consider whether trademark would likely to confusion. In the present case, we find no such opposition was made by respondent when the application for registration was preferred, and after granted registration. Then 24, effect of registration is provided in 27. This section, no infringement will lie in respect of unregistered trademark. However, 27.2 recognizes common law right to take action for passing off as the goods or remedies. My lord, this is the question of passing off. My lord, 27.2. Nothing, I've set it out, shall be deemed to affect rights against passing for passing of the goods. My lord, 28.3 is also material. My lord, 28.3 subsection 3. My lord, I can read it.
Yes.
A bare reading demonstrates that the following of the exclusive right in relation to obtain relief in respect in the manner. Then 27, subsection 3 of 28, with which we are directly concerned, contemplates situation where two or more registered proprietors which are identical to each other. It postulates a situation where the same name can be registered with more than one person. On a plain standalone reading of this section, it is clear that exclusive right to use any of those marks shall not be deemed to have been acquired by one as against the other owner of the mark, though at the same time they may have same rights against third person. Thus, between two persons who are registered owners of the trademark, there is no exclusive right to use the said mark against each other, which means this provision gives concurrent right to both persons to use mark in their favor. Otherwise, also, it is a matter of common sense, cannot say that its registered trademark is infringed by the defendant, is also enjoyed registration of mark, and such registration as well gives to use the same as provided in 28.1. Now, 28 says in the third line, it is stated at the cost of repetition, per this section, owner cannot sue for infringement of its trademark. Having said so, it is important considering at this stage, namely, whether such respondent can bring an action against appellant for passing off under 27.2. In other words, what would interplay and 23 is that arises in the instant case, as already in the trial court have granted injunction on the basis of prior user. I also say that you have a cause of action. May not kindly see 30. Firstly, proposition can be, then it says collective reasoning would show rights conferred by raiser are subject to rights of prior user. May not always prior user wins. May not, but you must have jurisdiction. My lord, this goes on and on. And 30.4, my lord, it says 34 has nothing shall entitle registered proprietor interfere. I'm leaving that. Then
So therefore, trademark infringement would not occur, but you can have an action on passing off.
Yes,
that is what you say.
and my lord, the learned judge is also aware of the same. Same.
And particularly, you have never disclaimed your gold.
No.
So, but they have disclaimed gold in respect.
My lord, even if I had disclaimed, my lord, everyone has to disclaim gold. Let's put it that way.
Generic.
Has to.
This is come back in 10 minutes.
Yes. Yes.
Yes, Mr.
My lord, the next decision
Yes.
on this is, my lord, Prakash Vanijya Private Limited versus Baroma, my lord, which is basically item 10 and at page 105. My lord, it is this case, I believe,
Now-
is it's 2018 volume
The index
16 SCC 632. This case has been referred by learned judge in the impute
Yes.
matter also.
Yes.
Now, my lord, page 105 at 106.
Hmm.
My lord, in the middle, last portion, paragraph 2,
Hmm.
on various consideration of various features of the respondent's then mark and other materials, learned judge, by order dated granted interim order observing there was similarity between two levels and restraint from using Malabar. Division bench declined to interfere with such order. While the suit and application for temporary was pending before learned judge, defendants filed application for vacating. Inter alia, on various grounds conceding that he is relying upon fabricated documents and the appellant cannot claim exclusive right over the mark Malabar and therefore interim injunction has to be vacated. More or less, my lord, disclaimer. Learned judge, by order which passed with consent, gave liberty to file supplementary affidavit to clearly indicate the device that the respondents propose to use. The respondents filed application indicating proposed modification of their label, changing the getup. After hearing the parties, interim order initially passed was modified to the effect respondents shall be entitled to use the word Malabar in conjunction with Boroma, where all words and reasons are etc., but the word may be increased with fund not more than 25% rest of the words of the letters. Being aggrieved, has preferred appeal from division bench. Division bench dismissed the appeal by the order holding learned has passed, balancing the interest of the parties. My lord, 5. Appellant is the registered owner of label mark in class 30 in respect of rice. Then the second line, Apple says biryani rice, and the most prominent feature of the label mark is Malabar. Appellant is granted registration for its products. Then little last line of that paragraph, in the registration under there is a disclaimer for the word Malabar. Disclaimer is worded thus: conditions, registration of this shall give no right exclusive word of Malabar and all other descriptive matters. The appellant, though, claims exclusive owner of the word Malabar. Since there is a disclaimer to exclusive use of the word Malabar, appellant has no right over exclusive use of the word Malabar. Respondents have also inter alia brought in record to show registration of other goods under 30 with the word Malabar granted in favor of Amalgamated Bean Coffee Company. The registration of Malabar Monsoon under class contains similar disclaimer, word Malabar. Likewise, label Malabar Coast has been registered in favor, which contains similar of Malabar Coast, etc., etc. Then para 7. Insofar as, excuse me, the label mark used by the parties is concerned, we have perused the label mark selling biri with the word Malabar and also modified the mark of the respondents. Label containing the words Boroma, Malabar, Gold are circled, have different get up from that of the appellants. By comparison, in our view, over a substance, there is no similarity. Now, my lord, and paragraph 8, having regard to various contentions subject to the suit, can pursue their application for registration of the device. So respondent can pursue. Both parties have raised concern, various contentions since suit of the respondent for registration of label under class is pending. We are not on the merits of this contention. So here it was not even, my lord. Yes, my lord, I'm sorry, yes. My lord, kindly see 107. Keeping the interest, last line, who are said to have substantial turnover in the business, High Court rightly held that the respondents would be entitled to use the word Malabar in conjunction with. So we are.
Disclaimer on Malabar.
Yes,
That's
because that is the effect, my lord,
Yes.
of a disclaimer. Now, my lord, then I go to this point, which I want to cite appropriate in one forum. You are saying this, then you are stopped basically to say something else, because the entire plaintiff, you will find they are claiming now right over the word gold. Also gold. That's their pleading, which you cannot do. My lord, there are short cases, my lord. My lord, contradictory stand before two different forums, my lord. And the first case on this, my lord, I want to show is, my lord, oh, yes. And a false statement is being made that I am the exclusive owner of a particular, my lord, mark, which contains, my lord, with the word gold. That's a false. If you make such a false, what is the effect? My lord, the first case I want to show is Raman Katra. My lord, that case is at page, it's reported in 2023, SCC online Delhi 38, my lord, Justice Bakru's judgment. My lord, page.
It's not there in the compilation.
73.
Yes, page 73, my lord, of the compilation.
Yes.
তারপরে
হ্যাঁ?
SLP
হ্যাঁ?
তারপরে SLP from the
ও এসএলটি আছে তো, তুই কোন প্যারাগ্রাফ আমি মার্ক করা নেই দেখছি রে। Yes, my lord, please come to yes, paragraph, yes, paragraph 43.
Yes.
We also find merit in the appellant's contention that a party that has obtained registration on the basis of certain representation and assertions made before the trademark etc. would be disentitled for any equitable by pleading to the contrary. So in one forum you have said this, you cannot to the contrary. Learned judge has referred to the decision of such and such, holding that grant of registration neither in the examination nor reply would be relevant. We are unable to agree with that view. In that case, court had also reasoned that there is no estoppel against statute. Clearly, there is no cavil with the proposition. However, the said principle has no application in the facts of the case. A party that has made an assertion that its mark is dissimilar to a cited mark and obtains a registration on the basis of its assertion is not entitled to obtain an interim order against proprietor of the cited mark on the ground mark is deceptively similar. It is settled law, person is not permitted to approbate and reprobate. A party making contrary is not entitled to equitable relief. May not, once you have in one, then may not, page running para 46, may not running page 85. A second line, a party approaching trademark registry must be held to the statements made before trademark registry and cannot be permitted to make a factual assertion contrary to what has been made before. For this reason as well, it is not permissible to claim goods covered are similar to those of the appellant. Now, my lord, This went up to the,
This was a submission and it was accepted.
oh, next 47. Thank you. Yes. No merit contention that has erred in not considering the appellate pedestal, and also learned judge has proceeded on the none of the trademarks used are registered trademarks. Now, my lord, this went up to the Supreme Court. My lord, page running in the other volume, you will find, my lord, that just 519, the special leave was dismissed.
Review 521.
And then, my lord, against this, a review was filed.
521, 2121. Next page.
Next page, 519 and 520.
521.
Oh, sorry, 521.
Yes, yes.
So review, my lord, this is the side. Having cited this, my lord, then the next judgment on similar thing is PhonePe. PhonePe's judgment, Bharat Pay and PhonePe.
8.
Kot re?
88.
My lord, in the compilation, it is page
88.
Yes, in 88, and for their convenience, it is 2023 SCC Online Bombay 764. My lord, please straight away come to para 12. The defendant filed its reply affidavit to the application as well as its written statement in the suit. Defendant has heavily relied on earlier proceedings between the parties, and it is submitted that the plaintiff has taken contradictory, mutually destructive stands in such proceedings, and that on this ground alone, the application deserves to be rejected. Then, my lord, it is submitted Delhi High Court has already held, while dismissing the application, that it cannot claim exclusivity of trademark pay. And the question is whether pay has become synonymous with the business of the plaintiff, if at all. My lord, they are saying gold has become synonymous. You can see the pleading I have pointed out, you have marked, my lord, on the previous occasion. Page 92, the defendant has heavily relied on the aforesaid order passed while granting conditional liberty to the for withdrawing. It is submitted that the plaintiff is not entitled to take a different stand for pressing heirs for grant of relief. Now, my lord, kindly come to 22. My lord, 22. This court is of the opinion that the defendant is justified in indicating that the said order between are relevant in two legal relevant, and that effect of the same can be taken consideration by this court to examine whether the plaintiff has indeed been shifting its stand, and as to what effect the same can be have on grant or refusal of discretionary relief at interlocutory stage. The plaintiff is not justified in proceeding on the basis present suit application ought to be considered without even looking at the earlier proceedings. Taking into consideration the specific stand of the plaintiff in the suit file, which is pending, as also earlier suit withdrawn, my lord, plaintiff has been shifting stands. Then, my lord, para 27. Para 27, my lord, to 32, where, my lord, prosecution history estoppel, the term is being used. My lord, 27. This court is of the opinion that by taking such complete contrary stand in respect of own registered PhonePe and no, not this, 28. In this regard, aspect of prosecution history estoppel assumes significance. My lord, I told your lordship this term is being, it's same thing, appropriate, reprobate, whatever, inside. My lord, only colorful expression.
Yes, yes.
My lord, in 27, in the middle, it is written clear contradiction in stance. My lord, in the 27 middle, it is said clear contradiction in stance. 28 says prosecution legal proceedings. My lord, if there is some quotation in the middle, once plaintiffs have taken stand in the opposition proceedings and they have suppressed it from the court in the present case, then the more their conduct can be safely termed to dishonest and blameworthy. This itself is claiming discretionary relief. My lord, this is my point in my vacating application. It's a case of suppression. You should have.
So, Mr. Bose, if we understand you correctly, please correct us if we are wrong. You are arguing this to counter their argument, which they may have, that this disclaimer is in respect of my trademark.
Yes.
But in my passing of action, this cannot have any effect.
No.
So that may be their
No, no,
argument.
I am because they have filed a cross appeal. No.
No, also that because the disclaimer in the trademark
Yes.
may affect their infringement rights on infringement.
I am only now addressing you on infringement.
No, but also in passing off, this will have an effect on passing off.
Of course.
They may argue that my disclaimer in trademark cannot prevent me from taking a passing off action.
My lord, the passing off, I will address you separately. I am only.
Estoppel also affects that.
Yes, I am only focusing now on infringement. When I say, my lord, I'll be addressing passing off. I will first, I will address you only if they overcome the question of jurisdiction. That will be my submission. My lord, after pointing out this.
But all the arguments will take all your arguments on all the points compositely.
Yes, yes, yes.
Make your alternative arguments.
Yes. Yes, yes. That I will come. My lord, yes. Oh, my lord. Your lord. It will. Yes.
Understood.
Of course, my lord.
Carry on.
My lord, my lord, my main thing is, I mean, like I said, they have given, say, 20 registrations. Say, this does not have, that does not have. When you have taken a contrary stand, you are asking for discretionary on the count of infringement. It's your duty to point out. I point out. Now vacate it.
Yes.
And this is not vacated. Now, my lord, 29, in similar situation in Sachdeva versus Educate, division found that discretion ought to be in favor who approaches with unclean hands. Ought not to be exercised. That was the backdrop, having suppressed its own stand taken before registrar during consideration of application for registration. Interim grant was set aside, indicating principle of prosecution history estoppel. Now, my lord, come to para 30. In the present case, it is an admitted position. Plaintiff did not place before this court its own stand when the registrar in examination observed there were earlier trademarks as phone pay deal, phone pay store, phone pay score, etc. Then para 31, third line, this court is of the opinion by not placing its stand before the registrar cited mark phone such and such, plaintiff disentitled it's a discretionary relief under order 39 rule 1 and 2. And here ex parte, Anton Filler, John Doe, and all these things may not happening. The test in such case is likely to suffer prejudice due to suppression. Our case is of suppression in the vacating. Discretionary ought not to be gone. In the present case is of the opinion, prejudice was caused to the, but the defendant making such and such. Then Miller para 32, hence court is of the opinion, is correctly invoked in the present case. Plaintiff cannot successfully claim discrimination in the backdrop of this conduct. My lord, এটা কিছু আছে ডিভিশন দেখিয়েছে কি না নেই না এটার মধ্যে my lord, yes, next case, no next case. My lord, Sudarshan seats dekhe diyechi.
What do you mean by no next case?
No, in my note. Now, my lord, oh, Sudarshan seat দেখায়নি. Page 5. My lord, next case is Sudarshan Seeds PVT Limited. Page 5, item 2. Page 5. Para 5, page 5 and 6. Small judgment.
Yes.
Yeah, key oh, your lordships. Why?
Yes. Not even a fiddle. In second fiddle, you need to be a fiddle. I was just fiddling when the judgment was being passed.
My lord.
Yes.
Oh, plaintiff is what appears to be a passing complaints interlocutory after Swarna Gangai paddy seed. There is no dispute that both the manufacturer sale.
This is only for the purpose of
the registered name in conjunction with Tiger brand. Then in the middle, essence of is that plaintiff starts duly applied for registration in relation to complying. Thus, plaintiff's case before trial court was that it was the registered owner of Tiger brand Swarno, and it was entitled to injunction against the herein for using part of such in selling paddy feed. It has now been admitted that the registered mark that they enjoys is only in respect of Tiger brand. Therefore, my lord, in para 6 it is said, principal case is one of infringement. Such aspect assertion is now accepted as inaccurate in view of false statements. No final relief was appropriately declined by, my lord, has been appropriately declared to the appellant. You cannot, may not this type of things make false. You must put everything. And I mean, this ex parte order, and then, I mean, Hindustan liver. No. What a passing of it. Hindustan liver is in passing off. Now, my lord, I have another last argument to make on infringement. And this argument will also be my argument with regard to copyright infringement. The argument is this court does not have the jurisdiction to pass any order for infringement irrespective of 134 and 62 of the Copyright Act. And I told your lordship in the morning why. My lord, the plaintiff the paragraph. My lord, one can, this ITC, you have decided, and I showed when I was saying all proceedings are being filed in Delhi except one in Calcutta in the list which they have mentioned. Very well, my lord. Now, where is that? My lord, one paragraph of paragraph volume 1 ta there.
Volume 1 of the paper book.
No, but one plaint is there, my lord. Just one averment. কোথায় আছে? যেখানে বলছে plaintiff through its agent হয়েছে. Where is that averment? My lord, just give me. I got
inextricably connected. Or?
No, my lord. Here it has said that through came to know in November.
Oh, statement to show is 1905.
My lord, just one. Yes, para 20, page 35.
Yes.
Plaintiff, through its market sources in Nakodar and Guntur, came to know. What were you showing? That is said. My lord, in such and such. Now, the plaintiff, my lord, has place of business, my lord, in Punjab. This is the proposition. I am totally in Punjab from the cause title. Do not carry any business. The John Doe's, my lord, go to Punjab because he knows. Yes, Nakodar and Guntur are those places in Punjab. Now, my lord, it's a point I want to raise. One knows that for pure protection, usually done because of protection of poor authors who want to protect their copyright, etc., my lord, that you sue wherever you want. Drag him, the defendant. He is not supposed to run everywhere, my lord, the plaintiff, for protection of his statutory right. That is the principle behind 134. That's right. Now, let me show you, my lord, one judgment on this, which I am advancing, my lord. And, my lord, if you, my lord, see this judgment, my lord, of কোথায় এটা কোন judgment? হ্যাঁ? হ্যাঁ। না, না, এটা কি? Which follows ultra. My lord, it's ultra home construction. Item 5, 2016 SCC. Item, my lord, 376. I think it's item 15.
5242.
Yes. I think volume, it's in volume 1 itself.
Volume 2, the first judgment. Lord.
Oh. এটাই তো? হ্যাঁ। Oh, yes, this judgment, Justice Badar Ahmed, madam. Yes. 2016 SCC Online Delhi 376. My lord, it follows a Supreme Court judgment of Dalia. Of Dalia, which is also in the compilation. Item 16, reported in 2015-10 SCC 161. My lord, passages from Dalia are there. My lord, in that, so I will not cite Dalia because it's already there in considered in this judgment. My lord, I remember the last paragraph or second last paragraph of Dalia is very important, because when the jurisdiction was being ousted, my lord, Delhi lawyers all came forward and said, no, Delhi, you can't, because we are, I mean, there's some passage also.
The lawyers were not in the matter also.
Who came? Everyone came. There is one paragraph, I think, as far as I remember. There is a, anyway, I am relying on 2016.
We are interested in that paragraph. Not
There
in
is
your
something I
proposal.
remember, Miller, since your lordship is...
Yes, you have read that paragraph. Those paragraphs.
Yes, something like that, Miller, I remember. When this came, then Justice Stanton was hearing the matters, in many matters. Dalia taken, I remember this. No, anyway, Miller, on this. Now, 242.
Yes.
This appeal has been filed against judgment delivered by virtue of the impugned judgment. The learned judge has dismissed a suit filed by on the ground court does not have territorial jurisdiction to entertain the same. Said dismissal limine without requiring presence of defendant respondents. Then, Melad, para 4. This honorable court, the government, territorial jurisdiction to try operates through its registered office. Plaintiff company carries on business in Delhi through its several exclusive agents. Has extensive goodwill. Similar averment is there, I think, in paragraph 1 or 2 of the plaint. By virtue of this, has territorial jurisdiction within the meaning within the meaning of section 134(2) of the Trademark Act and also under section 62 of the Copyright Act. Now, my lord, in paragraph 5, that my lord side, and you will find Supreme Court Sanjay Dalia is being mentioned. My lord, this is a quotation. Learned single judge also observed as under. I may note it is considered on behalf of the plaintiff the place of business infringing at Jharkhand has a hotel And if plaintiff has a hotel, can surely the plaintiff is carrying on business at that particular place, and carrying business is very much carrying on business of the plaintiff, and therefore the ratio of judgment clearly applies. Plaintiff is running the hotel, and the clerk in Gloat Hotel, plaintiff does have a share in the profits, losses, and run from with place at Deogar. Then, my lord, 6. Learned counsel submitted Learned single judge has not correctly appreciated the finding ratio of Supreme Court in Sanjay Dalia. It was contended that Supreme Court did not hold the jurisdiction of court where principal place of business or registered office and that copyright was situated would be ousted if cause of action has arisen at another place where the plaintiff also had similar activities. My lord, then a little below, placing Reliance Supreme Court in Dodak House versus it was contended merely owning a hotel would not mean carrying on business at that place. It was submitted even though has a hotel at Deogar, etc., etc. Para 7. Learned counsel appearing on behalf of the respondent submitted that learned judge had correctly held that this court does not have jurisdiction for entertaining the suit. It was contended that the appellant has clearly admitted it was carrying business at Deogar inasmuch it had hotel in that it was also submitted alleged cause of action had arisen in Deogar, Jharkhand. My lord, kindly come straight away. My lord, after my lord, section 62, 134 are my lord quoted, paragraph 9 at 247. My lord. On an examination of the provisions of 20 of the code, my lord, this is our civil procedure code.
Yes.
It is evident defendant could be sued inter alia where the defendant carried on business. Now, my lord, kindly come straight away to page 250, my lord, running paragraph 13.
Yes.
By virtue of the Supreme Court decision in Sanjay Dalia, this deeming position contained in explanation of the code has been read into section 134(2) of the Trademark Act and section 62 of the Copyright Act for the purpose of isolating the place of business where the plaintiff can be said to be carrying on business. It is to be noted, etc., etc. Then, my lord, coming to running page 251, my lord, where, my lord, in Sanjay Dalia quotation, paragraph 18, right at the end, page 251.
Yes.
On a due and anxious consideration of provisions of section 20, section 62, and the object with which the latter provision has been enacted, it is clear that if cause of action has arisen wholly or in part where the plaintiff is residing or having principal place of business or personally works for gain, suit can be filed at such place. May not pausing here. Then, may not plaintiff can also institute suit at a place where he is residing, voluntary or for gain, that the cause of action has not arisen at a place where they are residing, at anyone is residing, carries on business. However, this right to institute suit in such place has to be read subject to certain restrictions, such as in case the plaintiff is residing, having head office wholly in such as under the guise he is carrying on business at some far-flung places also. The very intendment of the insertion of provision of copyright is the convenience of the plaintiff. The rule of convenience has been given a statutory expression in section 20 as well. Now, my lord, straight away come to para 14. In the middle.
Yes.
The third case is where we are concerned with this. plaintiff has a principal office at one place and the cause of action has arisen at a place where its subordinate office is located. In our case, in this eventuality, plaintiff would be deemed to carry on business at the place of its subordinate office and not at the place. Thus, plaintiff could sue at the place of the subordinate and cannot sue under 134(2) and 62(2). My lord, para 15. The present case falls under serial number 3 in the above table. The appellant has its principal office in Delhi, place L. Its subordinate office is in Deoghar, Jharkhand, where it runs hotels Amrapali Clarks Inn, albeit in conjunction with Clarks Inn hotels. The alleged cause of action has accrued at Deoghar, Jharkhand. Therefore, appellant would, in respect of alleged institute against in Jharkhand, but not in Delhi. Now, my lord, please come. Oh, my lord, the chart, if you see that chart,
Yes.
yes, it may.
Please, that the
yes,
third.
Yes, the third. My lord, in paragraph again, in this Sanjay Dalia has considered the decision in Dhodas. I am not referring to that. Paragraph 18. The appellant has a clear admitted interest in Amrapali Clarks Inn at Deoghar. Then, para 19. Clearly, on the basis of averments itself, the backdrop in Doda House that carries on business, it may also carry on business at Delhi. But because the cause of action has arisen in Deoghar and not in Delhi, the cannot sue defendants in Delhi. My lord, this is one judgment. I thought I should, my lord, we usually do not point out because no one wants to oust jurisdiction of Calcutta High Court, my lord, but one judgment, this is one interpretation, it has been given considering Supreme Court.
They have not stated that they have an office in Punjab.
My lord, internet, they are one of the biggest in Punjab. Why would they? They have said
Their
through my
business associates.
yes, through my exclusive, I came to know. But in the yes, if you are taking it that way, my lord,
they don't say that we carry on business in Punjab.
No.
That they have an office in Punjab at least.
No. Nowadays, it says one of the biggest in Punjab. Calcutta, so it's just falling down. Roof is falling down.
We cannot put in personal knowledge here. I've been to Amritsar last vacation, so.
Lordship.
Yes, but plaint does not reveal anything. So we are looking at the plaint.
Well,
plaint does not say they have an office in.
Well, plaint says that paragraph I showed you.
They are through their business associates.
Business associate. I just, just one judgment. I wanted your lordship, and this will be.
Supreme Court.
Oh, this went to the Supreme Court.
Just bole
520, my lord.
Yes. Oh, yes, right.
That earlier Supreme Court, this also went to Supreme Court after.
And your lordship is saying that a plaintiff would foolishly, such a big company would foolishly say, I am also carrying on business.
Big companies are sometimes foolish.
Mistake.
Overconfidence, these things are there.
Yes. My lord, 520, my lord.
Yes, 520.
This special petition is was dismissed.
At the SLP stay?
Yes.
So then there is no merger.
No, but the judgment of the division bench.
You are disclosing.
That way, but considering Sanjay Dalia, those which is, my lord,
520.
Yes, no, not this.
Yes, right.
Yeah. And I'm not placing Sanjay Dalia again.
Because it has been extensively quoted.
2015.
And this ends, may not, because what I have to say with regard to infringement, but the main point is, may not, judge is in my, I'm just covering the aspect, my lord, of the cross appeal.
Cross appeal.
Main thing is learned judge has held, doesn't like. Now, my lord, passing off. My lord, please take section 134. My principal argument, I will tell you, lordship. First, I will say there was no occasion for learned judge to even consider such cause of action.
Trademark Act দিয়ে
My lord, there was no occasion because there was no jurisdiction to even consider. And about effect of clause, my lord, you can only entertain cause of action after leave is granted, like clause 12 of the latest patent. When part arose outside, part arose within, you grant leave, then entertain, then pass an order. My lord, here it's better. Here you cannot grant leave on the first day. You have to show cause. And the show cause is because you know it will not be granted. And that is why they have not prayed for leave on the first day. On the first day, they only got prayers with regard to the infringement bit. They did not press for any order and did not get any order for passing off. They know it doesn't lie. And because, my lords, you look at section 134C.
Additional jurisdiction granted to plaintiff.
My lord,
this is
134
no, it
1C.
update.
Trademark Act. Sorry.
Trademark Act, huh?
My lord, has your lord.
Trademark Act.
Why?
Perhaps your lordship is looking at the rules. The act probably will be right.
Yes. Yeah, we skipped over to the rules.
Rules.
Thank you. Yes.
My lord, it says suit for infringement, etc.
Right.
And says no suit for infringement of a trademark or right in respect of a registered trademark. Then, my lord, C is independent. For passing off arising out of any trademark which is identical, whether registered, shall be instituted inside. So, my lord, one is infringement, one is right in respect of registered mark, and C, my lord, is, my lord, with regard to passing off, and the explanation, my lord, of 2, my lord,
The purposes of
sorry, let me read 2. For the purpose of A and B, district court shall, notwithstanding another include district within local limits at the time of institution of proceeding, the person instituting,
plaintiff.
that is the plaintiff, or where there has been more than plaintiff, actually voluntarily resides or carries on business personally working for gain. The plaintiff. And the explanation is for the purpose of 2, person includes registered and registered user. And 2 will say for the purpose of A and B only.
So there is no qualifier, no such qualifier for C.
For C. My lord, C is an independent thing. And my lord, in fact, in all, I mean, that is why, I mean, the question comes, my lord, of, that is why, my lord, yes, you are right. My lord, you can go and order to rule 2 and not care about clause 14 at all. You can ask for order to rule 2, says this part has arisen outside, has arisen. Please give me leave, otherwise I can't sue. So grant me leave, and order 2, both previously or retrospectively, it can be granted. On the other option is you apply for leave under 14 and the show cause is issued. Now, my lord, $1 million question. Should you file an application? Leave under 12. Now, my lord, as I told you lordship that day, my lord.
You have a different view from the usual practice. You said.
Yes, I say because otherwise it's not feasible. like clause 12, revocation, you move it, whatever you are stating, my lord, it is granted on the same day.
No show cause.
There is no show cause. Then you file an revocation. Is the averment there or not?
Show
But
cause
in
period
a
causes
clause
an
14, how will you show cause? What, where, when? What is the lease? Because commercial suit, management issue, and all these things will come, technically speaking, if it is strictly followed. I mean,
But in the show cause order, it will be enumerated as to on what you have to show cause.
yes, you have to show cause.
So why is an application required? I mean,
When, show cause when, in which application? So when it will be heard?
on the plaint itself, I mean, can't
Or
you?
when? That's the question, Milord.
When is the question?
When, that is the question, because manager, that's the question. So, Milord, usually if there's a, something like a GA, it appears again in the list. And you have not shown cause. Or your infringement is established. Why will you not defend inter trial? Yes. Then give.
more importantly here the question is whether without a leave can an interim
Show cause in on the defendant to show cause as to why it should have been
Yes.
tried by this court.
Yes.
So that can, why can't that be done on the plaint itself, plaint averment and enumerated?
My lord, yes, when the plaint,
As to why you don't.
when the plaint will come up for hearing at the trial, yes, you do it. My lord, I am talking of a better case in that you want it now.
Hmm.
You know, whatever it is, there was no this hearing and no decision.
Show cause is there in the order itself. So it says
On
the ad interim order.
Yeah, just minute. Leave under clause 12, leave under this. Nothing.
So leave was granted under 14.
No, you can't.
Show cause was issued.
My lord,
That was your argument on that.
well, you cannot, because that's the language. Contrary to what clause 12 and what is exemption under rule 12 capital A,
Section 12.
it contains a show cause first. I haven't checked it, but there are many times if you don't and you grant it on the first day, it'll go.
Supreme Court এখন বলে দিয়েছে application লাগবে না।
Oh, now that new case which I told you, Lordship, now Supreme Court has said it's not required.
Application is not
required.
for clause 4.
Fine.
12A
12A. Now, Milord, our
12.
12A dispensation, not
Section two.
required. That's okay. Whatever, then if it is done, then you challenge it and it goes on. Milord, it'll go on. And Milord, same with clause 12, latest, clause 12 of the latest patent. Leave under clause 12 is, but you assume jurisdiction once it is given. You don't assume jurisdiction in passing off under clause 14 until it is given. That is my submission.
outside jurisdiction.
And admittedly, it is wholly outside jurisdiction. I'm in Punjab. That is my submission. I'll give you one case.
Railway division.
Milord, it is in the compilation. Yeah, page 7 to 12. Milord, item 3, Hindustan Unilever, 3 leaves India PVT Limited. Milord, this has been upheld in the before the division bench. Milord, our court. Milord, 2016 SCC online Cal 11151, 7 to 12.
Yes.
Milord, I am not placing again clause 12, because on that day I had placed. Milord, 7 to, yes. My lord, please come, para 3. My lord, here also, all these, yes. The moment those arguments are advanced by the respondent, learned for the petitioner takes a rebound and drifted from the stand in contending, instant suit is filed for infringement of copyright and not on infringement of trademark and passing off action. According to petitioner, the section 62 confers jurisdiction upon this court and therefore suit based thereon is maintainable. Now, my lord, para 4 in the middle.
Yeah, at the very outset,
Huh?
starting.
Yes, also, my lord, para 4. At the outset, this court must record from its memory what happened on the day when ad interim order was passed by this court. At the time of moving, it was argued before this court, several paragraphs were placed in support of the contention that the respondent is guilty of infringing the trademark and therefore order is required to be passed. Ordinarily, the plaintiff is not tagged when an application is moved as a new motion, and therefore the court has to rely on the copy of the produced by the party. It is not possible for the court to ascertain, in the absence of the plaintiff, whether any leave under clause 12 was sought or leave under clause 14 has been granted by the court. A glimpse of section 134 postulates that a suit for infringement of registered relation in a may be instituted in the original site of High Court if at the time petitioner voluntary resides, carries on business. A meticulous reading, more particularly, it was Lipton, when I'm leaving. Then please come to the next page.
There is no difficulty.
There is no difficulty.
There is no difficulty. In combining several causes of action in one suit, in the original site of the High Court, provided, my lord, please look at these words, a leave under clause 12 letters patent is first obtained. Otherwise, you will not have jurisdiction. In course of hearing, plaint was requisitioned from the department, and it appears neither leave clause 12 nor is sought or granted. It was
Here,
not
clause
to be
12,
sought.
clause 12, clause 14
Sought.
was sought
Sought.
in the plaint, and show cause was issued also,
Malad, it
but
is
not
saying
granted.
Sought, not granted. Now, my lord, kindly paragraph 5 in the middle, in the 5 lines, court was misled on moving the application for and securing ad interim order of injunction. The moment the respondent sought notice provisions of 5.2 in maintaining sudden drift of in confining argument to infringement of copyright, I must record should be more vigilant, circumspect, cautious in passing ad in and not solely on the advance at the bar. Then, and my lord, it got vacated, the interim order, and it was, my lord, then appeal was preferred. My lord, this order, it is not in the compilation I found yesterday. My lord, withdraw করে দিল না? My lord, sorry. My lord, they withdraw.
দিয়ে দাও কপি তো দাও তোমার একটু কাটতে withdraw পুটি withdraw করে দিন এখানে
My lord,
পরে দেখে
in the middle, second. My lord, you can see,
maintainable
Yes, yes.
about it was withdrawn.
Mr. Bose, we have fixed two matters, one at
Oh, yes,
five past one and one at.
Yes.
So we'll take up.
My
these
lord,
matters. So we'll stop it here.
Yes,
today.
next week, so it
Next
will,
week we it's closed. The week after.
by next
11
11th, then
whenever, my lord.
hard in part. Release the matter for further hearing on March 11, 2026. Okay. এটা কম্পাইলেশনের মধ্যে ঢুকিয়ে দিল।
পরের দিন হয়ে যাবে হ্যাঁ, তুই তোরা রেডি থাকিস,
হয়ে যাবে
না হলে শেষ করো ভাই।
বলে দিও যে নেক্সট উইক
এখানেই থাকবে, ঠিক করে এখানটা ঢোক। এই সিগারেট গুলো ওয়েট আ মিনিট মিস্টার চারদা, এটা ফেরত দাও, একদম রেখো না ফাইলে। জি
কোয়ালিটি সিগারেট
না স্যার আপনারটা ছোটটা আমার।
না আজকে দিন রোজ লোক দেখে এটা ছোট ওটা 1.5 ম্যাটার দিন একটা 5 একটা হ্যাঁ this is for extension Mr. Panet for extension
The other side mentioned
for extension but
for extension of interim order, my lord,
yes she's there yes you
About
mentioned for
7 years.
extension of it
Yes.
but 7 years later, the application was preferred for revocation or for recalling of a decree.
no interim order was granted
Interim order was granted.
so it's till February 28th will just extend it for a month every
It
time
could be taken up on a particular
no,
table.
every time we'll extend for a month we will assure you that we'll extending only for a month
There's some urgency, my lord. The client is
urgency,
not
no.
being able to bear the fruits of the decree. 7 years later, the recalling application.
all the clients in all these matters are suffering the same fate so the interim order granted earlier is extended till March 31, 2026 or until further order, whichever is earlier. Push-up, the matter shall retain its position in the list.
Grateful, my lord.
Yes.
Yes.
একটা দশকটা তো টাকায় একটা দশকটা আছে কিনা দেখ দেখে দেখি আছে কিনা বলছে একটা 10 বাজেনি ছিল দেখা উচিত
Please, my lord.
other side is there
My lord, my lord.
Oh, so, yes,
Friend is
yes.
appearing. Very eagerly.
Eagle is there.
My lord, only one difficulty. It's for leave, my lord.
Why was it mentioned?
My lord, because my lord, the checks are expiring today. There's a technical difficulty for which, my lord, we could not, my lord, put in the checks. I'll quickly indicate those parts. We have an application, my lord. This is IEGA 9. I'll just indicate two,
Application
three, my lord,
Yes.
page 47 is your lordship's order, my lord, by which there was a direction for changing the name of the account. And there, my lord, the operative portion is at page 49.
This was directed by way of a condition of stay or something.
No, my lord. This is, my lord,
Context just
an application was filed by my learned friend's client,
Yes.
my lord, to my lord, deposit, because we were depositing in terms of an order. My lord, to deposit in a particular name, the account name should be changed. So, my lord, that was permitted.
May I just, my lord, originally it started from the fact that, my lord, I had got an ex parte decree against him.
what sort of a degree did
Eviction decree. Now, my lord, that they had to, on condition it was recalled and
Yes,
they
that
were
is
going
what
to
we
pay.
asked, yes.
That's the whole
That's the genesis of them.
What happened was the entire rent was broken up into two parts. One was to be given to me and the other part was to be retained. Now, my lord, we find that the retention was, the entire amount has to be deposited to the registered original side. He was taking poundage. No party was benefiting. That's why we made an application and your lordship had clarified that now instead of the registrar, it will be given, deposited with HDFC Bank.
In the name of the suit.
In the name of the
In
suit.
the name of the suit. That was, my
And the
lord.
bank will give me my percentage and they will, and the rest will be retained. Now, my lord,
The operative part is, my lord, page
What is the
49, the
operative
second last line. Such new account shall be opened positively on or before 31st October 2025.
exceeded that
Thereafter,
time.
my lord, we wrote, that's, my lord, at page 51, we were informed by my learned
On the 31st
friends that this was, my lord, this page 51 was dated 31st of October. We were informed that the account has been opened. That's the last paragraph of page 51, my lord.
Yes.
Last paragraph, page 51, in the name and style, my lord, CS 45 2013. That was the name of the account. Pursuant to this, my lord, page 53 is the difficulty. We wrote to our clients, Lord Bharat Coking Coal, we got this check on 27th of November. We were supposed to deposit within 10th of every month. This was dated 27th of November. Post thereafter, my lord, since it was not, we were out of time. Every 10, my lord, subsequent checks also we could not deposit. It's all with us. But the date of those checks, my lord, expired tomorrow. My lord, if a leave is granted by your lordship, we'll deposit it today itself, my lord.
and I'm not sending in the bill, but the prayers are a little difficult. Kindly see the prayers at page 10 and 11. It says the same thing. It says deposit with the registrar.
Lord,
Yes,
kindly,
that has been
my lord,
changed. He must have.
I have not seen this application. That's the difficulty.
I can make out. my lord. So kindly to that extent, my lord, your lordship, my lord, clarifies.
Learned
The
counsel appearing for the appellant submits that comma vide order dated comma that vide order dated September 24 2025 comma the court had directed an account to be opened in the name of the suit positively on or before October 31 2025 Full stop. Next para. Such account was opened and duly intimated to the learned respondent through counsel. Full stop. However, comma, the subsequent check, comma, which was due to be deposited within the 10th of November 2025, comma, was obtained only on November 27, 2025, and as such, the same could be deposited. Full stop. Accordingly, comma, the subsequent deposits till date could not also be made. Full stop. Next para. The appellant now seeks acceptance of the said belated deposits upon condonation of delay uh, in terms of the order dated September 24, 2025. Full stop. Next para. Learned counsel appearing for the respondent points out that the prayer made in the application is defective to the extent that deposits with the registrar has been sought for. Full stop. Learned counsel for the appellant clarifies that it is a typographical error. Full stop. Accordingly, on the prayer of the appellant, comma, we modify the prayers made in the present application, and comma, upon condonation of the delay in depositing the amount due since November 2025, comma, the appellant is permitted to deposit the entire dues till date in the concerned account in the name of the suit by tomorrow. We are giving you 1 day because by tomorrow. Full stop. Next para. In the event such deposit is made, comma, the same will be constituted to be in consonance with the direction dated September 24, 2025. Full stop. It is made clear that the subsequent deposits shall be made by the appellant in time as per direction dated September 24, 2025.
Now, my lord, one clarification, I suppose, since we don't have to come back. But now what happens is the entire amount that they are supposed to pay has to go
Entire
to
amount of
HDFC,
arrears till date. Yes.
HDFC, and HDFC will remit 30% to me out of that. That is exactly what the other. But, I'm sorry, the 30% will be retained and the rest 70% would be given to me.
Needless to say, comma, the HDFC Bank, comma, where the concerned account the HDFC Bank, comma, with which the concerned account has been opened, comma, shall remit the dues of the respondent in terms of the earlier arrangements in respect of the entire amount of deposit.
But kindly mentions that order, otherwise, my lord, again, my lord,
Date of the
yes,
order.
that
That's
is
my lord at
20th December, 20th December 2019. In terms of the order dated
20th December.
20 December 2019.
Earlier arrangement যেটা বললাম within bracket pursuant to the order dated December 2019. Right. ঠিক আছে?
I'm very deep, you guys.
এখন দেখো না কেন না
একটা দরকার রাখলো মাথাটা চলে যাচ্ছে ক্লাস
Yes,
Withdrawal, my lord. Appeal for
please. Yes.
Lordship,
My lord,
my
follow.
No, no, you first. Yes.
Your lordship is pleased to grant leave to my learned junior, my lord, to mention the matter, my lord. Kindly have a look at the order, my lord.
So what you want now?
My lord, mediation, kindly have a look at the order, my lord. Mediation has failed, my lord, unfortunately. And my lord, I am the worst sufferer, my lord. Kindly have a look at it. Let it be mentioned, my lord. Mediation has failed. Your lordship is pleased to.
We'll take after some time. The appeal is to be taken for hearing. So we'll take after some time.
My
We
lord.
have some matters. Yes.
Lordship may be permitted to mention for inclusion in daily list, Lordship.
What is the matter? About
Lordship,
it?
on the last
What is the
occasion-
heading?
Oh.
Please ascertain, then come and mention. Yes.
Lordship, I have a urgent mentioning in the matter of FA number 3.
Under what? Application or what?
Uh,
Appeal hearing?
Upon hearing.
Hearing we are not taking up now. Yes.
To be mentioned for reaction to file.
Please.
Lordship application.
But application.
Yes.
My lord, this matter for filing updatation, my lord. I've been trying for months to
Upgradation we
get
can't.
this matter updated, my
We
lord.
won't give particular privilege to a particular matter now. Yes.
Lordship, inclusion for an application.
The application is. Call on the list. Yes.
Lord, I beg to appear on behalf of the petitioner, my lord.
Yes, we should go.
Pursuant to your lordship's direction, my lord, affidavits are complete. My lord, the interim order is expiring on February 28th, my lord.
Will extend for a limited period.
And if your lordship kindly fixes any
Matter will be directed to be listed. Yes. The interim order granted earlier is extended till March 31, 2026. Full stop. The matter be listed under the regular heading on in the monthly list of March 2026.
My lord, can I file the affidavits, my lord?
Affidavit of service.
No,
Sorry?
reply, my lord.
Affidavits in opposition and reply filed to be kept on record.
Much.
Yes. Who is for the appellant?
For the petitioner.
Yes. What is the matter?
We have filed for extension matter.
Extension of what?
Interim injunction. We got an injunction.
Yes.
Restraining the defendant from changing nature and character.
What does the appeal arise out of, Mr. Shah?
Out of the an interim injunction, refusal of an interim injunction.
This court had granted you injunction.
No, the learned trial court rejected.
No, this court had admitted the appeal and granted injunction.
Yes.
When does it expire?
9/10/2023
Oh,
admit করেছিল এটা কত last কত অবধি order
it was it was granted till when?
last order টা কোথায়
It has expired long back.
Now
10 weeks from date.
we filed the extension application within the time.
But which is the extension application? Can
4. Can 4.
Can 4 আছে কোথায় can 4 টা কোনটা এখানে আছে ঠিক দেখে নিচ্ছি
Can 4. প্রথম অর্ডারটা দেখি
এটা প্রথম অর্ডার এটাকে আমাদেরকে কি করেছিল
You serve a copy of this application on the other side. We'll grant you. We'll extend for the limited period.
We have served.
You have served Can 4.
No.
Can 4 will direct you to serve. We are granting extension for the time being. We find from the order dated October 9, 2023, that an interim and ad interim order of injunction was granted, but there was no formal admission of the appeal. However, from the tenor of the said order, it is evident that the intention of the coordinate bench was to admit the appeal. Accordingly, we deem the said order to be an order of admission of the appeal as well. Next para, the interim order granted on October 9, 2023 is extended till disposal of Can 4 of 2024. Full stop. Next para. The appellant shall serve copies of Can 4 of 2024 on the respondents, indicating that the application shall next be listed for hearing on March 16, 2026, when an affidavit of service to that effect shall be filed by the applicant.
Interim injunction extension.
Ask your juniors then. Yes, next. Yes.
My lord, I'm praying for not this week, my lord. On the basis of that, I had a discussion with Mr. Bose. Mr. Bose did not appear on the last occasion, and your lordship gave last chance. I have taken instruction that there is genuinely a discussion of settlement is going on.
Then it goes out of the list for the present.
Affidavit in reply be kept in record.
No, opposition has been filed by
Yes,
lordship.
yes. I have
Affidavit in
also
reply filed today by the respondent be kept on record for learned counsel for the parties submit that talks of settlement between the parties are going on. Accordingly, let the matter go out of the list with liberty to mention as and when such talks of settlement are concluded either way. If it fails or if it culminates in a good, in a settlement, then mention. Next.
For the appellant, opposite party in application can do yesterday, my lord, since
None
no one
appeared.
Yes.
Move the matter.
In this matter, I have a point of maintainability of this can, because initially I was protected by an ad interim order. That was ultimately, my lord, rejected by Order 39 Rule 1 and 2 by the order impugned before your lordship. Your lordship reimposed the order that is still disposal of the application. Now in the interregnum, what they are seeking, they are asking from some modification of that order, not modification, they are asking, Lord, that they should be give access to such. Lord, this is something for the first time, Lord, beyond the scope of this appeal. Because this prayer was neither there before the
Let us hear Mr. Chakravarti, then we'll discuss.
There is a premises, my lord. I am the owner, my lord. I enter into the agreement with the developer, my lord, file and my lord, put for declaration, my lord, thereafter interim order rejected, thereafter my lord, come appeal.
They filed the suit. You did not file.
They filed suit. They filed.
They are the owners, you are the developer.
I'm the owner.
And they are the developers.
No, they are the they are my lord, one thing, they are a co-owner, my lord, they are a right title interest in respect to the property.
The suit is for what? Declaration of what?
Gift deed cancellation.
You are not prepared, Mr.
Cancellation of gift deed.
He's having to tell everything, then let him move the matter.
His matter, he is dealing with this matter.
You are not your matter.
But my prayer is that the interim order, my lord, rejected. Thereafter, my lord, came up that without due process of law, they are trying to evict them. Lord, I am not trying to evict them. My lord, no effort was made for evict them. Your lordship passed the order, remand the entire, my lord, proceedings that till disposal of the suit, not to disturb their position.
You agree to that?
Agree to that.
But you are disposing of the appeal right now?
Problem is that, my lord.
Yes.
By this order, my lord, we are occupying one portion in the upper, in the first floor. They are occupying the.
You are also being prevented.
I am also prevented by this order. Police also said that as per order of the honorable court, we are not interfering.
As per your plaint case, what is your case? That you are in. That you are in occupation of the entire.
I am the widow of his brother. So he is a married daughter. He is not in. She is not in possession. She, my lord, engaged a developer. Admittedly, a development agreement has been executed whereby the developer has been, my lord, empowered to pull down the existing structure and to make construction. That's where the protection your lordship has granted, because ultimately, apart from the gift deed, I have a right of residence over the property.
It is a totally.
Now, you are who? You are the.
I am the, my lord, the original owner. My lord, is according to me my father-in-law.
Your father-in-law.
Yes, and the entire business was run by my father-in-law and my
husband is no longer there.
My husband is no longer there.
You are, and another means your
my
child,
son.
Your son. So you say that your son was in exclusive possession of the property.
Yes, me and
you
my son.
seek a co-ownership.
I say, my lord, that by virtue of that, my lord, I challenge the deed, so I remain a co-owner over the property.
The deed was executed by daughter.
By the daughter, not by the mother-in-law in favor of the daughter.
Gift deed.
Gift deed. So that was challenged because I said two things. First, the property is originally belongs to my father-in-law.
But Mr. Mukherjee, then she is also a co-owner.
I am coming to that. She is.
What about
the problem remains? This lady, my lord, is a married lady. She is really not interested to live in the property. That's why, that's why, if this point will be agitated, if this point will be agitated, I will have to come back with the opposition, because
Milord, what she want a caretaker to be put into the property. A third party should be there by virtue of this Milord application, and an innocuous prayer is being made as if an access to be given to her.
Let us see the prayer.
Yes, kindly takes up Milord the prayer, appropriate order. The prayer is at page 13, Milord.
No, creating obstruction towards her free ingress and egress.
Yes. So, Milord, if your Lordship make it clear, it is her free ingress and egress. What she wants by.
So she doesn't want. She says only her ingress.
Milord, I'm admitting. Milord, this is for the first time. This
The prayer is only
being
her
made.
ingress and egress.
This is.
But do you have any proof that you are in exclusive possession?
Yes.
Exclusion of her.
Exclusion of her, because she is married lady, Milord. She is residing with her husband.
Married lady also in eviction suits also we say that
Milord,
married lady
yes,
has
yes.
a.
That's why, Milord, this particular allegation, Milord, when the affidavits and counter affidavits has been exchanged in
No, we
connection
can dispose of the appeal as rightly suggested by your learned friend.
your Lordship can give.
We'll maintain the injunction in a favor, but we at the same time will clarify that you cannot restrict her ingress and egress to the
But
property.
that's where, Milord, today, if your Lordship grant them liberty to file the exact same prayer before the trial court, we can thrash out, Milord, before, because this needs.
This is not a new prayer as such. This is not a new prayer we are saying, because in the trial court there was the occasion for them to make this prayer, because as per them they were also in possession, joint possession of both of you. Now what they are saying now, this is in way a modification of the order we have passed, not a new prayer altogether, because they are saying by virtue of the order we passed in your favor ex parte at that stage, their right has also been curtailed. So this pertains to the order we granted in your favor.
Very well, Milord. May
I new prayer as
may I just use a short opposition to this, so that, Milord, I can venture before your Lordship what is the predicament on my part. I am not, Milord, resisting her.
How can we be sure sitting in appeal that you are in
No, Milord, your
exclusive possession, particularly when you also admit that you are joint owners?
No, Milord, ultimately at the end of the day, I cannot claim exclusive ownership, because if the deed
Ownership
even
you are
goes,
not claiming.
yes, exclusive ownership I cannot claim.
Possession also you have to be sure.
That's where
You
I want
don't
to
have a
file
case of ouster anywhere.
I have to file an affidavit to that effect. Only to, Milord, canvass before your Lordship what is the predicament of my
What
client.
is the predicament?
Predicament is, Milord, by virtue my clients, Milord, by virtue of this order, what her intention is to, Milord, induct or put a third party into possession.
There.
Yes.
I'm admitting.
No, we'll clarify that they will not do that.
Yes, Milord.
Clarify that.
After that, but till disposal of the suit. I'm not problem. No,
You can degree the suit also if you want.
10 rooms, Milord. 5 rooms in the first floor, 5 rooms on the
We don't
floor.
know which is in
That's
occupation.
where, Milord,
This was at the ad interim stage.
Ad interim stage. Milord,
initially ad interim I was protected.
No,
but
trial
at the
court passed
final,
an ad interim order.
no, ad interim.
final.
That's protected thereafter after considering all the
But
aspects.
Shakuti, the difficulty is the moment we say that, then you'll go and disturb her person.
Milord, kindly visualize, Milord. I am a senior citizen, Milord. The mother, Milord, sold the property in her business, gifted me. But I am not in a position to enter into the premises. I'm not.
There are other criminal proceedings pending.
If not,
have your belongings in any of the place?
Yes, is will first.
Have you pleaded anything?
First floor in the first floor.
Show us your pleading in this application. Where have you stated that you are in occupation of which particular portion? Nothing.
Yes.
Only the merits of the matter on law.
No, your Lordship,
Yes, para 16. Please,
para 16,
don't know your
entirety.
Please read your own application, please. You should come prepared in a court of law. You have stated in para 16.
Entirety.
You can't even say that. This is the entire ground floor and first floor.
Entire ground floor and
What
first
is the number of stories in the building?
2 stories.
Ground and first.
10 rooms total. 10 number.
Milord, really there are criminal cases pending.
This will create a problem.
I'm not evicting them, Milord. I'm not evicting them, Milord.
That's why I do not want that.
Earlier also, Milord.
Mr. Chakravarti, we have not restrained you from entering into the property. We have stated you cannot disturb our possession. This is the only injunction.
Yes, Milord.
You are trying to create a confusion by saying this, that you are also in occupation. Where is the proof of your occupation?
Milord, at present,
you will just come and disturb.
By filing this case for
you have pleaded here that you are the entire property is under your occupation.
But for not dragging this matter, Milord, at this moment, Milord, I am submitting before your Lordship to dispose of as early as possible, not to drag. That's why, my lord, for shortcut
But
method.
Mr. Chakraborty, we appreciate that shortcut, but the difficulty is the moment we say, your ingress and egress won't be prevented, and in the light of this averment that you are in occupation of the entire property, whereas you are a married daughter, we don't know whether you are in the property. You claim possession in respect of the entire property. No, if we permit this ingress and egress to the entire property to you, please let us complete the sentence. This is not done.
Whatever lordship thinks fit and proper, my lord, ingress and egress in the.
In any event, even if you don't say it, whatever will think fit and proper will be done. But you have to hear what we are telling you. You have pleaded here that you are in occupation of the entire property, Mr. Chakraborty.
Yes.
Now you are seeking an order whereby your ingress and egress to the entire property won't be disturbed with them.
Yes, sir.
That by that process you will be ousting her.
Admitted fact that I was possessing in the entire property.
Who admits that? Where is the admission?
That is, my lord.
What do you mean by admitted fact?
When the contradiction.
Where is the admission? Show us the admission. Admitted fact. Show us the admission in their application.
So, my lord, kindly appoint any.
No, you are saying admitted fact. Let us see the admission.
That is, my lord, then, my lord, I file.
What then? Show us from the plaint or their injunction application. You are making a submission before a court of law. It's an admitted fact. Show us the admission from their plaint is before you. Their injunction application. Then why do you say admitted fact?
Fact according to the.
Admitted fact can be according to someone.
Yes,
They have to admit. It's not an admitted position. They assert that they're in exclusive possession. You are trying to disturb them. Why should you grant you an injunction as you are praying? That will be deleting the effect of the injunction.
First floor occupying was asked, ground floor occupying by them now. Now, my lord, after
we'll direct affidavits, we'll hear the appeal on merits.
After, but my lord, I'm a senior citizen, my lord, my property.
By what is your age? What is your age?
60 above, my lord.
60 above means?
Lord, affidavit in
up to 100, 110, 20, 200, all is 60 above.
64.
54?
64.
64. Not old enough.
Oh, my lord.
Very young.
Visualize, my lord. It is my emotional attachment also, my lord. Dear, my lord. It is
we fully visualize your emotional attachment.
Yes, my lord. So, my lord, kindly, without disturbance, my lord.
Yes, we'll direct affidavits. No.
But for dragging, my lord, I am wanting, if your lordship, to remand this case, my lord, give protection to
all wants are not fulfilled.
Give protection.
All wants are not fulfilled. What can be done? You waive this application. We are sustaining the order we have passed in their favor, and do what you want. We'll remand it back, but without this order which you are seeking. You are trying to negate the effect of our order.
My mother gifted me. Give something, my lord.
You'll get the entire property if you win this. If you win this suit, you'll get the entire property. But you cannot disturb their position.
Not disturbing a lot.
What you are wanting?
What
are you saying, Mr. Chakraborty? Yes, we may appear to be sometimes a bit below IQ, but always it's not true. Sometimes it's true also. You are seeking an injunction on the averment that you are in occupation of the entire property. You are seeking an injunction that they may not disturb your ingress and egress. That means they may not disturb your ingress and egress regarding the entire property on your averment that you are in occupation of the entire property. Now, we have granted an injunction in their favor, restraining you from disturbing their possession. Isn't it patently contradictory? Wouldn't it negate the effect of our order? And you are saying it's an innocuous prayer.
Finally, my lord, humble submission before your lordship. This is one room occupied by them in the advestor room.
That is not your. There is malafidis in your application. You say you're in occupation of the entire property.
Occupation in the
prove that you're in occupation of which portion of the property. We will grant you that.
Supplementary affidavit file.
Why supplementary affidavit?
Application.
You have claimed here entire occupation of entire property. You have to prove that on this.
Then, my lord, your lordship, my lord, kindly appoint any.
Why should he? He'll go and there. He'll see they are standing on the roof and he'll come to the conclusion. Occupation cannot be ascertained.
In the first floor, in the lock and key.
Yes, the special officer, we are appointing you and your learned friend, the special officers. You go and see the belongings, which belonging your name is stamped, and all these things.
My mother's property gifted me, my lord. My belongings here. I am occupation in the first floor.
No, that will negate the effect of the entire order we have passed.
When I want to, my lord, go.
Show us you are in occupation of the entire property. You are married elsewhere, you are living elsewhere. Show us that you are in occupation of the entire property.
Kindly give me time.
Time to do what?
Next,
show us on this application.
The application, my lord, is the voluminous application, my lord.
This is the voluminous application.
Their petition also, my lord.
No, their application. From your application, show us you are in exclusive occupation. Show us one document or anything.
That's why, my lord, by annexing the document, I will file a supplement affidavit. I'm trying to some
On the prayer of learned counsel for the
with documents, my lord, I will file a supplement.
on the prayer of learned counsel for the respondents stroke petitioners in Can 2 of 2026, 2025, leave is granted to the respondents stroke petitioners to file a supplemented affidavit to TO2 Can 2 of 2025 within a week from date. Full stop. Next para. An advance copy of the same shall be served on the learned advocate for the appellants. Full stop. The appellants shall file their affidavit in opposition, shall file their composite affidavit in opposition to the application bearing Can 2 of 2025 and the supplemented affidavit within a fortnight thereafter. Full stop. Reply, if any, shall be filed within a week thereafter, within a week subsequently. Full stop. The matter shall next be listed on March 30, 2026 under the heading applications.
Great.
Next. পুরো বাড়িতে থাকে বলি বেসিক না নেবে তবে কি সরিয়ে দেবেন ভাইয়ের বউটা এই খুব 2 নম্বরে আছে মনে শুনে টিভিতে আছে Yes,
on the last occasion, your lordship has recorded in the order that your lordship will be pleased to hear the appeal and the application, the appeal which arises out of an Order 7, Rule 11, filed by my learned friend's client and allowed by the learned judge. By taking into consideration the documents, Lord, that they have filed at the time of hearing, Lord, I'll confine myself, Lord, to Lord, the principles of Lord, disposal of Order 7, Rule 11.
So should we look into the impugned order first?
My lord.
Should we look into the impugned order once?
Lord, your lordship may kindly have a look into the impugned order. And they have, Lord, also in the application, not only about, Lord, that non-disclosure of the cause of action and suppression, they have said that this is a, Lord, a vexatious litigation. It should be nipped at the bud by exercise of powers under 151 also.
So the suit was one for?
For a declaration. For a declaration, and Lord, your lordship will find the prayers at page 190. For a declaration that the plaintiffs are lawfully entitled to possession of and remain in possession of the property situated at 24/7/1 Raja Santosh Road, such and such, more fully described in the schedule to the plaintiff without any interference or disturbance from the defendant, their servants. Perpetual injunction in connection therewith.
What is the right you are claiming in the property?
By purchase. I'll take your lordship in the plaint.
The trial could relate
Your
on
lordship
what?
will kindly come to Lord first the order. From the order, I'll not then take your lordship to the plaint.
Yes.
But the order is at page 219 to Lord the stay application.
We are following the memo of appeal. You can refer to the internal page.
Very well, Lord.
Yes.
Now, Lord, the defendant's case has been noted at Lord first page. Thereafter, Lord, the plaintiff's case is noted.
Defendant's case in the Order 7, Rule 11.
Yes, and thereafter, Lord, the argument on behalf of the defendant noted at internal page, Lord, internal page sort of yes,
Suppression of another
3 of 9. And Lord, the decision with reasons comes at page 4. I'll start with the decision with reasons.
Very well. Yes.
But if it required, Lord, I can do an elaborate hearing, but because of the paucity of time, Lord, I'm trying to just compress and Lord, just give Lord my points.
Thank you. Yes.
I have considered the points of argument advanced by the learned advocate of both sides and perused the pleadings of both sides. It is a proposition of law that an application under Order 7, Rule 11, read with Section 151 is to be adjudicated covering the pleadings of plaintiff only, and apart from plaintiff, nothing more is to be seen. Absolutely correct. And the documents appended to the plaintiff are also to be seen. Here in the present backdrop, it appears that the annexures filed with the plaintiff contained the judgment and decree passed in title suit number 17 of 2002 and nothing more. On the other hand, the defendants have filed 1. The indenture between Jyoti Kumar Rajgaria and present defendant company, 2. Deed of conveyance for the year 1961, which is the chain of title of Jyoti Kumar Rajgaria. 3. The proceeding of land acquisition by the land acquisition collector in respect of premises number 32 Raja Santosh Road. We have not on 24/7/1 Raja Santosh Road. 4, the order passed by Honorable Justice Pinaki Chandra Ghosh in GA number such and such. 5, the judgments and degree passed in title suit number 17 of 2002 and title suit number 39 of 2013. 2002, my lord, already referred to by me in the plaint. Chronological order sheets in title suit number 17 of 2002. The order passed by the Honorable High Court in CO number such and such. The order passed by Honorable Court in CO number such and such. I perused all the documents filed by both the parties. Now, my lord, almost a mini trial comes. It appears that the plaintiffs did not disclose the matter of other suits where he was litigating parties in respect of the suit scheduled properties. The suit scheduled properties 24/7/1. In the plaint, it is not disclosed how he gathered right, title, interest, and possession in respect of the suit scheduled property as premises number 24/7/1, Raja Santosh Road. But I will refer to the plaint paragraph. The judgment and degree passed in title suit number 17 of 2002 as it appears show the subject matter strictly as premises number 32 Raja Santosh Road, which is not at all premises number 24/7/1 Raja Santosh Road. In this juncture, the version of the defendant supports the allegation of suppression of material truth. Peruse the direction passed by the Honorable Justice passed in GA number such and such, which is submitted by the defendant, where the matter of report of the joint receivers is apparent. The joint receivers were directed to execute deed of conveyance for transfer of the entirety of the said premises number 32 Raja Santosh Road in favor of the plaintiffs. In this order, I observe that the direction of the delivery of possession is for premises number 32 Raja Santosh Road, not for premises number 24/7/1 Raja Santosh Road. So it is apparent that the plaintiffs have got possession in respect of premises number 32 Raja Santosh Road. The entirety of premises number 32 Raja Santosh Road is indicated in the order. The present plaintiff have nothing to show that any further survey commission was done to show that premises number 27/7/1 Raja Santosh Road is part and parcel of premises number 32 Raja Santosh Road. I perused the order passed by Honorable Court in CO number such and such, where the Honorable Justice Harish Tandon has pointed out that the learned advocate appearing for the added defendant tried to impress upon this court that in the garb of premises number 32 Raja Santosh Road, the plaintiff petitioner is really trying to recover possession from his client who has a semblance of right, title, interest in portion of premises number 24/7/1 Raja Santosh Road, Kolkata. The aforesaid submission has no basis for the simple reason that the plaintiff petitioner have taken a specific stand that the suit is restricted to the premises number 32 Santosh Road, Kolkata, and such admission has been recorded in an earlier revisional application filed before this court, and this court has clearly in an express term recorded the aforesaid submission, which would bind the plaintiff petitioner at all stages of the procedure. From this direction of Honorable Court, it is clear that the premises number 32 Raja Santosh Road is separate than that of premises number 24/7/1 Raja Santosh Road, and the plaintiffs in the instant suit submitted no rebuttal point against that. The judgment and degree passed in title suit number 17 of 2002 filed by both the parties shows confinement within premises number 32 Raja Santosh Road, and the plaintiffs have not filed any document along with the plaint which shows their right, title, interest, and possession in respect of premises number 24/7/1 Raja Santosh Road. But this document was appended as an annexure to the injunction application. I am still carrying it. My learned friend can rely on that. But I have in the plaint indicated about my devolution of title by reference to a registered deed. The defendant have filed documents relating to land acquisition proceeding in respect of premises number 32 Raja Santosh Road, which I do not consider in this periphery, since the defendant have not brought any counterclaim in respect of the property. There is no reason to enter into the same, as no point comes out from this proceeding about the nexus between the two numbers of premises in question here. The other suit which were dealt with by the plaintiff was suppressed in plaint, and those documents are shown by the defendant wherefrom it is apparent that there was a partition suit between the plaintiff and Bijay Pawani, which ought to be brought by the plaintiff in pleading. The result is also not disclosed, for which the standpoint of the plaintiff are exclusive possessions is not clarified. It is rightly pointed out by the defendant that the conducting advocate in title suit number 17 of 2002 and the instant suit is same, for which it is expected that every nook and corner would be disclosed, but in reality there is practically suppression of fact about the previous litigations involved with the two number of premises in question. Next, I would like to come into the point of cause of action. In this regard, I observe that the plaintiffs have brought the cause of action in this way, that the defendants are denying the title of the plaintiff and they are disturbing the peaceful possession of the plaintiff. On careful perusal of the entire plaint, I find no act of such challenging on the part of the defendants. The cause of action does not indicate any single sentence, but it is togethering the facts made out in the plaint, making a bundle of facts for plaintiff backdrop of title and the present scenario of getting disturbed in possession should contain. The cause of action disclosed here is not properly framed. That is not the judge's not finding. The cause of action is to be taken which gives the plaintiff the right to relief against the defendants. Every fact which is necessary for the plaintiffs to prove to enable them to get degree should be set out in clear terms. The cause of action must include some act done by the defendant, since in the absence of such an act, no cause of action can possibly accrue. Law does not permit a person to get relief in respect of a property to which he is not entitled. And here I observe that the Order 7, Rule 11, A and D, read with Section 151 of Civil Procedure Code, is applicable appropriately. The learned advocate for the plaintiff has referred and relied upon the decision of the Honorable Court reported in such and such, which is actually the great action of the key action or dedication of the Honorable Apex Court, in which the point of adjudication, the provision of Order 7, Rule 11 read with Section 151 of the Civil Procedure Code is applicable. On careful perusal of the decision, I find that the plaintiffs failed to reach the standard of cause of action made out in the plaint so that the plaint can be entertained. Nowhere in this decision it is pointed out that the suppression of fact can be entertained till evidence period. Learned advocate for the defendant has referred and relied upon the decision of the Honorable Court reported in such and such. I have perused all the decisions of the Honorable Court carefully and respectfully. The decision reported in 2025 SCC Online SC 703 points out that plaintiff must disclose such facts which are necessary for adjudication, and suppression of fact is not encouraged. Disclosure of cause of action is very much important. On the other hand, the point of baseless cause of action resulting into meaningless litigation is discouraged. In the decision of the Honorable Court reported in 2012-8 SCC 706, the learned advocate has shown that one cannot seek relief to get a property to which he is not entitled. The decision reported in 2015 SCC Online empowers the court to reject a plaint where meaningful reading of the plaint it is required to find out if the ground stated in the plaint calls for dismissal of the suit. Suppression of fact in plaint is discouraged here, which calls for rejection of plaint. In the other decisions relied by the defendant speak in the same tune, and nowhere it is supported that the suppression of fact will empower the plaintiffs to get relief to a property which is not actually in his rightful authority. Considering all these facts and circumstances, this court observed that the plaintiff has suppressed the previous litigations and specifically the partition suit. The plaintiffs have suppressed that there was previous decision of Honorable Court regarding separate identity of two premises in question. Premises number 32, Raja Santosh Road, and premises number 24/7/1, Raja Santosh Road. But to this blood, the finding kindly mark. These two are separate premises.
That is the finding.
That is the finding.
And Justice Tandon's order is referred to
But
for that purpose.
We are not litigating in the 24/7/1. And how I am litigating, I am going to show.
Very well. Yes.
The plaintiffs ought to furnish document of ownership in respect of the suit scheduled property being premises numbers 24/7/1, Raja Santosh Road, which the plaint neither discloses nor any supporting document is annexed with the plaint. The cause of action does not include the act of denying ownership, and the cause of action suppresses the act of ownership also. The cause of action suppresses the interest of other co-sharers also, and the result of partition suit is not brought forward, considering blood thereafter it was rejected. Then blood, your lordship will kindly come to blood the plaint at page 177. Now in the plaint, paragraph 1, the plaintiff above named are lawfully in possession of the suit is valued at 38 crores or not. This is a big property. The plaintiff above named are lawful in possession and occupation of premises number such and such, situate at ward number such and such. Hereinafter referred to as said property. The said property situate within the jurisdiction of the learned court, more particularly described in schedule herein. The defendant number 1, Magma Leasing Limited, is a company within the meaning of Companies Act and having a registered office at 24 Park Street outside the jurisdiction of this learned court. The defendant number 2, Olonkar Financial Services Private Limited, is a company within the meaning of Companies Act and having its registered office as such and such. Defendant number 3, Sri Ayush Bagla, son of Sunil Kumar Bagla, residing as such and such. Huh? Oh, struck off হয়ে গেছে। ঠিক আছে। Then, Lord, the derivation of title at paragraph 3, prior to 1981, one Saeed Imam Ali, Begum Gulanar Bibi, and Jamilai Khatun, Mahmuda Khatun, and Jabeda Khatun were the owners of land and structure at premises number 24/7, Raja Santosh Road, situate within the jurisdiction of this learned court. By a conveyance dated, but this is where I am stating. 2nd December 19, predecessors, Lord.
Yes.
In respect of, Lord, the property which is 24/7, it is by numbered. Because why it is by numbered, I'll also explain that. By a conveyance dated 2nd December 1981, registered with the sub-register of Alipur, book number such and such, being number for the year 1981. And by another conveyance dated 1981, registered in such and such for the right, title, and interest to and in landed property of area of 18 kata 35 square feet, equivalent to 1207.274 square meters of land, together with several huts, together with 21 feet passage connection to the said premises to the Raja Santosh Road, were conveyed to Krishna Nandan Sahai, Srimati Shakuntala Sahai, Keshava Nanda Sahai, Kumud Nandan Sahai, Bimala Sahai, Shashi Sahai, Rajiv Nandan Sahai, Amita Sahai, and Sanjeev Nandan Sahai by the vendors named in the said conveyances who are owners of the said property. The property conveyed was a portion of municipal premises number 24/7, Raja Santosh Road, within the limits of such and such. Thereafter, kindly come to the next page. Note the second line, by virtue of the said two conveyances, an area of 1207.274 square meter was transferred and conveyed. The remaining part of premises number 24/7, Raja Santosh Road, measuring about 327 square meters, has also remained in possession and occupation of the plaintiff since December 1981 without any interruption. I pause here for a moment, Lord. So far as your Lordship has seen, Lord, that 24/7, Lord, comprises of two parts. One is conveyed by, Lord, two of the deeds referred to, other, Lord, in possession according to the statement of my client. So, Lord, the learned judge's finding that there was no statement about how I devolved, Lord, the title, Lord, that is not, Lord, a correct, Lord, observation by the learned judge. So, Lord, Lord, it is said that said property delineated in the map or plan attached here to and marked as X.
You say the remaining portion was never ever and is not a part of premises number 32.
That is, Lord, but
categorically say that.
Yes. Lord, all that I say that, Lord,
why do you need to say this all on a sudden? I mean, let us see. Read on. Yes, something must
because,
be
Lord, if your Lordship kindly comes to, Lord, the schedule, your Lordship will kindly see, Lord, on the
boundary
east. Yes. On the east is 32.
All right.
Page 193.
Very good.
Page 193.
On the south is 24/7, other part.
Yes. Because, Lord, this portion is purchased by the conveyances by numbered on mutation in 1981. 24/7, the remaining portion, Lord, which was unsold, that is 327, is in possession, but I am not claiming to be the owner.
But that is also, you say, a part of 24/7.
That is, Lord, I say my property is 24/7/1, on which I seek the declaration by 1.
Watch.
By 1 is, Lord, carved out of 24/7. That is the parent property.
All right.
Separation, mutation, that happens.
So you said 24/7 was carved out into 24/7/1, which is your purchase property.
24/7 is, Lord, the parent property.
Yes.
Of which, Lord, I purchased, Lord, a portion by two deeds.
Yes.
That is 1200 something square meters.
So up to paragraph 4, we find that you have purchased a portion of 24/7. Rest you were in occupation, apparently adverse possession sort of. So still we are on 24/7. We don't find anything regarding 24/7/1 till now, till para 4.
Para 5.
Yes.
Page 193.
Now in para 5 you state that.
Yes. Number last 5 lines.
Yes.
The plaintiffs have always maintained and secured their possession and occupation of the said property being 24/7, which now known and numbered as 24/7/1, which is more particularly described in schedule to this plaintiff.
But as per this sentence, Mr. Mukherjee, your entire 24/7 has become 24/7.
No, not
because you say the plaintiffs have. Sorry. Yes.
I understand what is falling from your.
As per the construction of this sentence,
it says that not 24/7 in its entirety is in possession of the plaintiff. And in the previous paragraph, it says how the possession
part purchase, part occupation. Yes. And then you say the plaintiffs have always maintained and secured their possession and occupation of said property, being premises number 24/7, which is now known and numbered as 24/7. So you don't segregate that in this sentence.
That portion, yes, your lordship is right. That how much of it is 24/7, how much is not 24/7.
But as per this, the entire property is 24/7, which qualifies 24/7.
Now known and numbered as 24/7.
Let us proceed. Yes, yeah.
But I will proceed on the basis of not my title deed. I cannot not go beyond my title.
Very well. Yes.
Then Lord 184, that plaintiffs have since 1981 without any interruption remained in possession and occupation of the said property, and their use and occupation and continuous and other without any interruption. Plaintiff had also duly mutated the said property in their favor, and the plaintiffs have been paying municipal rates and taxes, which is now numbered as premises number 24/7/1, Raja Santosh Road, municipal assessee number such and such. On or about 20th September 1989, one Jyoti Kumar Rajgaria instituted a suit being title suit number 54 of 1989, which was subsequently numbered as title suit number 17 of 2002. In the court of the learned civil judge, senior division at Alipur against Krishna Nandan Shohay and 8 others for declaration of the plaintiff's right and title. Krishna Nandan Shohay is the plaintiff in this suit and defendant in the previous suit.
No, Krishna Nandan Shohay is your predecessor.
My predecessor.
One of your predecessors.
Yes.
We saw the names of the fathers also to understand.
Yes.
Yes.
Yes. Therefore, they are the plaintiffs in this suit.
Keshav and Krishna, these two names we found as your predecessors.
The Shohayas are us.
You are the Shohayas, yes.
For declaration of the plaintiff's right, title, and ownership in respect of the suit premises, harsh possession thereof, perpetual injunction.
This was regarding 32.
This was 32.
Yes.
Mandatory injunction restraining the defendant from such and such. In a proceeding being GA number such and such, the Honorable High Court was pleased to appoint Mr. Porito Sinha and Mr. Devanjan Mondol as joint receivers, and liberty was given to the receivers to conduct the above suit being title suit number 54 of 1989. Thereafter, pursuant to another order of the Honorable High Court, the premises number 32 Raja Santosh Road was sold to the plaintiff of that suit. The said sale order was made pursuant to the terms of settlement filed by the parties in CS number 73 of 1997. The plaintiff of this suit were never party to the said CS number 73 of 1997. The defendant number 1 and 2 in this suit were granted leave to be substituted as plaintiff in the suit in place and state of joint receivers who were representing the original plaintiff Jyoti Kumar Rajgaria. At the point when the judgment was delivered and a decree was passed in that suit, the defendant number 1 and 2 of this suit were plaintiffs in that suit, and the plaintiffs in this suit were the defendants in that suit. So, my lord, what is there is a disclosure in the plaint.
But this is all of a sudden. Previously, you say the plaintiffs of this suit were never party to the CS 73. In the middle
that is
of
the High Court suit.
High Court suit.
High Court suit.
And then you say at the time when the judgment was delivered and the decree was passed in that suit.
That is, Lord, that suit refers to that Alipur court.
But it's
court
a
suit.
continual thing.
I know, Lord, the sentence framing is, Lord, maybe jumbled up.
Judgment delivered in that suit.
No.
You see, we are reading that you continuously refer to CS and then say the defendant plaintiff of this suit were never party to that. Defendant numbers 1 and 2 in this suit were granted leave to be substituted as plaintiffs in the suit in place and state of the joint receivers. So joint receivers still pertains to CS, who are representing the original plaintiff Jyoti Kumar Rajgaria. Then immediately thereafter you say at the time when the judgment was delivered and the decree was passed in that suit, the defendant numbers 1 and 2 this suit were plaintiffs in that suit. Doesn't mean anything actually. And the plaintiffs in this suit were defendants in that suit.
Lord, that is Lord, referring to that Lord, the previous suit of 54. But your Lordship is right, because Lord, the way that it has been framed,
yes.
the way that it has been framed.
So these are contradictory statements. Let us see.
But there's no contradiction, Lord, in terms.
Yes.
As well.
Because in the middle of para 9, Mr. Mukherjee, after about 10 lines from the top, you say, after CS7, the plaintiffs of this suit were never party to the said CS number 73. And then you say, and the plaintiffs in this suit were the defendants in that suit when the judgment was delivered in that suit.
Right.
This is the
right. Lord, what that has crept in here is that Lord, the sentence starting from the said sale order up to Lord Jyoti Kumar Rajgaria is not concerning Lord CS 73. That
yes,
is Lord,
it's a continuous statement.
It is not Lord in a chronological manner.
Achha, very well. Let us see whether that
suit is not different. Now, the plaintiff in that suit contended that the defendant and or their main agent and servants and agents wrongfully trespassed into the same and belonging to the plaintiff in that suit as
so
the
see, you are still referring to CS. No, that suit. So in the middle, it cannot be a disjunctive thing. It's a continuum. It's also speaking. The plaintiffs in that suit contended the defendants and their main agents trespassed into the same land belonging to the plaintiffs in that suit as the same was a part of the premises. Now, which is that suit?
Well, that is 54. 54. I will show Lord why
TS
it
54.
TS 54. Because the degree in the TS 54 and
Yes,
all,
that,
that will
you may have a point there, Mr. Mukherjee, because the first sentence of para 9 says conduct the above suit being TS number 54. So you also refer to TS 54 in paragraph 9. Anyway, utterly confusing. Couldn't blame the court. Easiest way is to reject the pen.
But
right?
Lord,
we are now convinced of what played in the mind though. Anyway, let us.
But Lord, just framing of Lord of a few sentences in the plain, that doesn't warrant Lord a rejection.
What few sentences?
Lord, only one sentence your Lordship will find, Lord, there it is juxtaposed. Maybe one after the other, Lord, it should have been.
Anyway, let us go. We are still wondering which suit you are referring to.
But Lord, that is neither here nor there. Because, Lord, I will show Lord, I am claiming from Lord my purchase.
No, para 10 may mean you are referring to that to TS 54. Why you are saying this? This is for Mr. Datta also because it's but against you in a sense because same plaintiffs in that suit contended that defendants such and such trespassed into same land belonging to the plaintiffs in that suit as the same was part of premises number 32. This could not refer to CS because CS is in respect of 32. So that suit is a part of 32 means that suit is 54. Very well. We are writing
the question
54
is not whether at this stage, Lord, the court should go into all these facts, Lord, in Order 7 Rule 11 stage. Because, Lord, there is a disclosure.
Your plaint is sufficient. Order 7 Rule 11 is good. We think non-disclosure, apart from non-disclosure, complicated disclosure should also come in Order 7 Rule 11. So anyway, let us see para 11.
Only one sentence, Lord, here and there.
Yes.
The defendant in that suit denied that the description of the suit property in the schedule to the plaintiff was correct, and the plaintiffs in that suit were dishonestly trying to include the defendant's property by falsely claiming that to be the part of the plaintiff's property, and the story of trespass and encroachment was totally false.
So all these are TS 54.
TS 54. The plaintiff in that suit mischievously sought to amend the description of the suit property in the schedule to the original plaint, and there was various proceeding with regard thereto. Ultimately, the suit was tried on two issues along with the other issues as specifically framed in the suit, namely, did the defendant trespass in the suit property, ? And are the plaintiffs entitled to recover possession? Both the issues were decided against the plaintiff in that suit. That suit is A54. And it was held that the plaintiffs failed to prove the encroachment and the plaintiffs were not entitled to degree of harsh possession as claimed in that suit. Plaintiffs are not entitled to degree of harsh possession as claimed in that suit. That suit means 54. Plaintiffs were not the defendants here in this suit.
So their case, the plaintiffs in the in title suit 54 of 89 ran a case that you were trying to encroach their property, encroach upon 32. That was disbelieved as per your case. Disbelieved, their title was declared regarding 32, but it was disbelieved that you have encroached any portion of 32.
That was in respect of 32.
That was in respect of 32. They have title in 32. You have not encroached in 32. Very well. Now let us see.
The suit was decreed partly in favor of the plaintiff to that extent, and that they were entitled to the declaration of their title in the suit property being 32 Raja Santosh Road of that suit. The said suit was decreed on 14th December 2017. This is 54. Copy of the said judgment and decree of that suit is annexed and marked as letter A. It was established in that suit.
Yes. Yes, quickly complete, Mr.
It was established in that suit that the plaintiff in this suit never trespassed or encroached anybody's property, and it was established that they have all at material time remained and still remain in lawful and peaceful possession of the said property. That is 24/7/1 Raja Santosh Road. The plaintiffs all throughout maintained physical possession of the said property through security guard employed by them even now with regard to the possession, occupation, use and enjoyment of the property, which is the subject matter of the suit. This suit is enjoyed by the plaintiff as they are lawfully entitled to do so. So far as the plaintiffs are aware, the aforementioned judgment and decree dated 14th December 2017 are in full force. The same is binding on the parties here too. Having failed to obtain the decree for recovery of possession, the defendants are now wrongfully and illegally trying to forcibly obtain possession. After the attempt to obtain possession in due course of law failed, the defendants are desperate and they are trying to take possession with the help of musclemen and antisocial element. Just for the purpose of show, they have employed their own security guards to create an impression to the person of locality that defendant number 1 and 2 are in possession. The said property is guarded by security men employed by the defendants. Although security guards employed are not encroaching into the property of the plaintiffs, they are creating pressure by remaining just outside the gate of the said property. They are watching and besetting the said premises and disturbing the ingress to and egress from the said property. These acts are wrongful and illegal. The plaintiff having approached the police, I am not taking your lordship into that. Then paragraph 24 is the paragraph in support of my degree of perpetual injunction. But again, at paragraph 25, their constant attempt to disturb my position and enjoyment. But I suffered a considerable loss and order to rule 2. And the cause of action of the suit first arose when after the aforementioned judgment and decree dated 14th December 2017, the defendant started to recover possession having resort to extra-legal method. The suit is filed within the prescribed period.
Unhappy drafting. Started to recover possession.
At times,
attempted to recover possession.
It could have been a better way of expressing.
Yes, started to recover possession.
Yes,
and then
we are constrained by our the knowledge in English. We can't help at times.
That's true. That English is none of our mother tongue, so
yes,
it may happen.
That is the reason.
But here the rest of the language does not match the rest of the language.
I understand.
Looking at the rest of the language, it seems that it is his mother tongue or her mother tongue. But suddenly it becomes father tongue.
Then, paragraph 27 and 28.
Situated at
now, coming back, to my point of argument, before your lordship.
Yes.
That whether at this stage at Order 7, Rule 11, when there has been a substantial disclosure.
What about this partition suit you have suppressed? Please elaborate on that a bit, Mr. Mukherjee. What is they have run a case because
I'll take your lordship to their contention in the Order 7, Rule 11. I am not besieging your lordship that your lordship embark upon a detailed trial at the stage of Order 7, Rule 11.
No, unless there's a gross suppression, certain cases probably it has been held.
Now, nature of gross suppression, that what they are trying to make out in Order 7, Rule 11, that if it is a triable issue, that should be relegated for trial. If it is apparent from the document, which I might have suppressed, then 151 may be invoked at times.
If you disclose the chain of events which leads to your cause of action in your plaint, that is sufficient.
So, as far as the plaint goes, I have shown my documents of ownership.
Document of ownership, yes. You have
mutation.
Referred to a previous suit in which you have alleged that they tried to say that you have encroached upon 32. And one paragraph you have said it's a part of, they tried to make out a case that is a part of premises 32 or something like that. From transferring any part of the suit premises, in SC 32. So they have failed to make out the case in 32. They have failed to make out a case that you are encroaching on 32. But the link between 32 and 24 by 7 by 1 is not clearly established in your plaint.
Two things come, Lord, that I have purchased not by two deeds, part of 24 by 7. I have mutated and have this separated as 24 by 7 by 1. Although I am occupying the entirety of 24 by 7 that I have stated in my paragraph in the plaint. But in the schedule, I have described 27 by 24 by 7 by 1 to be the property. That is my purchase portion of the property that your lordship will find at page 193. I have given the area.
Yes. But you have not distinguished between the purchase portion and the occupied portion.
Lord, in the body of the petition, Lord, I have.
Yes.
Because I have included, Lord, that.
The scheduled property includes both.
Scheduled property includes, the area includes both. But so far as the municipal premises number is concerned, that is 24 by 7 by 1, which is the mutated portion of my client.
You have said that you are in occupation of two portions of 24 by 7. One portion by two deeds purchase, other portion forcible occupation.
One is 1200 something square meter,
yes.
Another is 300 something square meter. Added up, your lordship will find 1534 square meters.
So you include the entire property, occupied property and purchase property in this schedule.
In the
and
area.
You seek a declaration of your title. Not title actually. You have not seen.
No, I have not. My title is never disputed. It is all that they are not threatening possession. Possession.
You're entitled
Title
to possession.
Is not never disputed by them.
So you want a declaration regarding
I
possession?
say that I am still in possession and you cannot transgress into my property and disturb my settled possession.
So apparently they produce something to show there is a partition suit between your co-owners and you.
But they are trying to not say that. Now, your lordship will kindly come to their order 7 rule 11.
Yes. No, you may run a case that even if they say so, you're in view of the frame of the present suit.
It's a tribal issue.
Yes, it's not only a tribal issue. You are not seeking a declaration where co-owners would be, absolutely necessary.
Not an issue.
Parties, yes. They are disturbing your possession as co-owners. Even if you seek a declaration of their possession, and if you run a case of adverse possession regarding the rest, then you don't admit the co-ownership of others.
I have not stated about the adverse possession. I say that I am
you
in
have
possession.
Not stated either. You have said you are in
possession.
Not that hostile against the true owner. They have not stated. Very. 711.
Now, your lordship will kindly come to the bunch of document that they have relied upon. It is not appended to my application. That is the filed by my learned friend.
কোথায় ফাইল দেখে?
13 January ফাইল করেছে।
কোথায় বাঞ্চক? আর কোনো আছে ডকুমেন্ট?
এরকম একটা ডকুমেন্ট দেখুন তো বাঞ্চ
13 January
সিনা ডকুমেন্ট দিয়েছিল বলছে, এখানে তো নেই।
আপনি অ্যানেক্স করেননি কেন এটা?
দেখুন হারিয়েছেন কোথায়? শিওর দেখুন।
আমার কাছে আর একটা আমার বিষয় থাকবে। I can blood.
You don't have copies of it. আর কোনো document নেই তো?
Order 7 rule 11.
You're sure you have filed Vishad Datta on the last occasion? This is nothing else is on record. May not have been filed. যখন আপনি বলছেন ফাইল হয়নি, নেই তো ফাইল। আরে নেই নিশ্চয়ই, দেয়নি ফাইল। Copies were given to you.
কেন আপনি বলেন ফাইল করেছিল?
ফাইলড অন দ্যাট ডে। ফাইল করেছে কি কপি সার্ভ করেছে?
কিন্তু আমি প্রমাণ দেখাতে পারছি না ফাইল করেছে।
হ্যাঁ তো কপি সার্ভ করে ফাইল করেছে। লাস্ট ডেট ইজ ফাইল।
প্রমাণটা নেই যে ফাইল করেছে।
If it was filed, we might have given it back because we have not recorded anything as
records that once
generally we record. That's why there is no recording. We tried to find out. Might have been you brandished those and we returned it. You have copies. Mr. Mukherjee has given 2 copies to us. Then we'll rely on these documents.
They kindly come to Lord. এটা তো paginate করা আছে না, paginate ও নেই তো। The second
We have
page.
copies. He has given us 2 copies.
But the second page of that bunch of document and application under Order 7
Yes.
Rule 11. Lord, but kindly skip over Lord to paragraph 3 at internal page 3. Lord, the first 2 lines, the plaintiff have no cause of action for filing the suit, nor does the plaintiff disclose any. Third page.
Yes, the plaintiffs have no cause of action.
Lord.
No cause of action cannot be a ground. Non-disclosure of cause of action can be.
Yes, that is. Oh, A.
Yes. So anyway,
the plaintiffs have rather categorically demonstrated in paragraph 17 of the plaint that there exists no cause of action justifying institution of the instant suit. Further, the relief claimed in the plaint barred by law. Instant suit is entirely based on falsehood, and the plaint and the injunction application palpably suffer from suppressio veri and suggestio false, whereby material fact and documents have been suppressed, and on that count, the suit deserves to be dismissed in exercise of plenary powers of this court under section 151 of the Code of Civil Procedure. Your plaintiff states that from a bare reading of the plaint pertaining to the present suit, it would transpire that the suit evolves from a decree passed in title suit number 17 of 2002 on 14/12/2017. This is disclosed. Sorry? Title suit, yes, this is 2002 suit is equal to 54. That was renumbered.
Oh,
kindly, that might be not leading to 2054 of কত সাল ওটা?
89.
From a meaningful reading of the plaint filed in title suit number 17 of 2002, it shall transpire that the same related to premises number 32 Raja Santosh Road, as also evident from reading of the plaint of this suit. From the reading of this suit, it doesn't appear that 32 is a part of it. 32 is on the west of it.
No, it shall transfer that the same related. No,
as also evident from reading of the plaint of this suit.
Because in your plaint you have said that TS that TS was the subject matter there was 32.
Yes, in previous suit it was 32. No doubt about it.
Saying it shall transfer that the same
related to premises
to 17.
As also evident from reading of the plaint of this suit. Oh, yes, I understand. As
of the plaint of this suit, it relates
they admit.
It shows that reading of that plaint relates to such and such. Anyway, forget that. Yes.
While decreeing title suit
distant cousin, draftsmen were distant cousins of each other. Not even too distant.
I'm really confused by this suit and that suit between.
You have met your match. And whoever is the yes.
While decreeing title suit number 17 of 2002, the learned
we are the word sufferers. Justice Bhattacharya and I.
While decreeing title suit number 17 of 2002, the learned coordinate court was pleased to confirm the right, title, and interest of the present petitioners in respect of premises number 32 Raja Santosh Road, and such decree was based on the schedule to the plaint filed in title suit number 17 of 2002. The plaintiffs in the instant suit have made an attempt to trace the cause of action to file the instant suit by relying on title suit number 17 of 2002, which was related to a property distinct, separate from the property involved in this suit. In a desperate attempt to portray such illusory cause, the plaintiffs have also cleverly drafted the plaint to create an illusion. It is thus established from the plaint that the plaintiffs have no cause of action to institute this suit, nor the plaint discloses any enforceable cause of action. The instant suit is thus wholly misconceived and is an abuse of the process of law, and its continuation would lead to unnecessary wastage of precious judicial time. But it is simply, Lord, a rhetoric statement made here. Why? Why do you make this allegation? This is not there. Then, Lord, your Lordship will kindly, but then again, the paragraph 5 is not full of context.
This catches the spirit of the matter. Unnecessary wastage of.
Yes, Lord, that is
not previous judicial time, but precious.
Precious.
Yes.
Precious. Let us read it as precious. Then, Lord, at paragraph 6, they talk about res judicata. It is reiterated that the plaintiff do not have any cause of action that could have justified institution of the present suit, nor the plaintiffs have been able to disclose any, which could have possibly conferred any clear right to sue. The annexures which have been relied on in support of the averment made in the plaint were not only parts of the previous suit, being title suit number 17 of 2002, but were also considered and adjudicated upon pursuant to which the judgment and decree was delivered in such and such. It shall appear from title suit number 2002.
Yes. No, please continue, because have you said that you purchased 32?
I've never said so.
You have never said so, apparently. Para 7 says that it's evident that you have purchased. Para 7 of order 7 looks at 11. What have you said there that you
It shall appear from title suit number the defendant acquired their right, title, and interest in respect of premises number such and such. The defendant, it appear from title suit number 17. The defendant acquired their right, title, and interest in respect of premises number 32 Raja Santosh Road by virtue of purchasing the same in the court sale conducted by the Honorable High Court.
Yes,
such right has been further confirmed by the decree passed in title suit number such and such. By filing the instant suit, the plaintiffs are only trying to circumvent the decree passed in such and such. Then paragraph 8, it's also significant to note that the plaintiffs were always aware of the fact that the premises number 32 Raja Santosh Road was sold by the Honorable High Court at Calcutta in its civil original jurisdiction after publication of advertisement. In fact, the premises number 32 Raja Santosh Road has been conveyed to the defendant number 1 and 2 by none other than the receivers appointed by the Honorable High Court at Calcutta to institute the instant suit. The plaintiffs have camouflaged an illusory cause of action to circumvent the intent and purpose of the orders passed by the Honorable High Court at Calcutta in CS 73 of 1997, Magma Leasing Limited versus VHEL Industries Limited and others. It shall be apparent from the meaningful reading of the plaint that by way of filing the instant suit, the plaintiffs have actually called upon the learned court to revisit the case, which has been decided only by the coordinate bench. The plaintiffs have also virtually invited the learned court to sit in appeal over the orders passed by the Honorable High Court at Calcutta. It shall appear from the schedule of the plaint filed in title suit number 17 of 2002 that the same pertained to 32 Raja Santosh Road. The said previous suit was decreed in favor of the plaintiff, thereby upholding the schedule of the property. The present suit relates to 24/7/1, which is different premises, and as such, no benefit of a decree passed in respect of a separate premises can be claimed by the plaintiff to have given a right to sue the defendant. So kindly mark these sentences. The instant suit is thus nothing but a clear abuse of process of law. This is clearly a fictitious proceeding founded on falsehood and gross and material misapprehensions, which should disentitle the plaintiff from getting any relief from this learned court. The plaintiff, while asserting their purported right over the relevant land, have also grossly suppressed that there is a purported suit for partition between the plaintiff and one Bijoy Pawani, being titled suit number 63 of 1990. Whereby the title of the plaintiffs have been disputed by said Bijoy Pawani. The photostat copy of the pleadings, several applications and affidavit filed in title suit number 63 of 1990 are annexed and collectively marked as Annexure B. I pause here for a moment not to submit on instruction that this particular suit was pertaining to the unsold portion of this property.
Which were in possession of?
300, yes. 300 something that square meter.
Title suit 63.
Yes, of 1990 between Vijay Pawani. It has been suppressed by the plaintiff that the said Bijoy Pawani has also instituted a civil suit against the defendant and the plaintiff, which has been numbered as title suit number 39 of 2013.
Mr. Mukherjee, please give us half a minute.
Lordship.
(24/7), which is now. Yes, please continue.
Lordship. Now, my lord, they at paragraph 13, my lord, talk about, my lord, another title suit, which is, my lord, title suit number 39 of 2013, whereby it has been asserted by said Vijay Pawani that he is entitled to valuable right in respect of premises number 24/7 by 1, Raja Santosh Road. It is further averred and said Vijay Pawani are jointly in possession of premises number 24/7 by 1. However, in the instant plaint, there is no disclosure of such suit. Photostat plaint filed in such and such is also annexed herewith. It shall appear from the meaningful reading of the pleadings filed in the aforesaid two suit, being title suit number such and such and title suit number 39 of 2013, that the title of the plaintiff are itself under cloud, and it shall also appear that such suit relate to the self-same property, and the plaintiffs having full knowledge of the same ought to have disclosed such material fact. All such material fact have been deliberately been suppressed in the suit. It is also interesting to note. So, my lord, this is, my lord, what that they are really contending, that, my lord, between me and Vijay Pawani, there are two suits pending, of which, my lord, I did not,
Yes,
my lord,
your
disclose.
exclusive title and possession are both clouded.
Yes,
apparently.
but, my lord, to which our answer will be, my lord, it doesn't really affect, my lord, the defendant, because the defendant doesn't, my lord, take any claim against, my lord, the title of in respect of this particular property.
Mr. Mukherjee, in your first relief in the present suit, you have claimed for a declaration of title, declaration of possession in respect of the entire property.
Lord.
See, Pawani has a suit against you,
Lordship.
and he seeks a joint possession. Wouldn't that be a material?
Lord, it is for
fact
the court
this?
to find out, Lord, that how much I am in possession, the grant relief by molding the relief. But that doesn't
It's an
entail,
unpartitioned property.
my lord, the suit is to be, my lord, rejected.
But
at
even
the
as per
threshold.
you, it's not a partition property regarding the portion which you're in occupation of and the purchase portion.
But so far as
the joint portion clouds your exclusive portion, which is the first declaration you have sought.
But I'll just try to explain. But so far as the portion that I have purchased, but there is no cloud to that, not the purchase deed. That was in 1981. Now, Lord, that was a demarcated portion which I had purchased, not 1200 something square meters.
So at least part relief you are entitled to it.
But all that I say, that the court, by Lord, resorting to Lord, what that has been contended
711
in
is
order
this
7 rule 11 cannot Lord reject the plaint at the threshold.
Yes, maybe.
It is not my contention. I am not also taking your lordship as to whether I am correct or they are correct. But if I run a prima facie case, a triable case,
yes,
Lord, the court cannot say that it should go because, Lord, it is not credible.
Very well.
It is also interesting to note that the plaintiff in the suit and the plaintiff in title suit number 39 of 2013 were being represented by the same lawyer, and as such, it was imperative that true, proper, and faithful disclosure ought to have been made while instituting the instant suit. It has also have been suppressed that from an interlocutory order of adding said Vijay Pawani as a party in title suit number 17 of
Let us not go into the question of who is the lawyer of whom. We have your bunch, the front page.
But,
yes.
Same lawyer.
Lawyer, receiver.
Yes.
All together.
Lawyer's personal knowledge will not.
No, not at all.
Why not him?
Sina company.
An order has been passed by the Honorable High Court at Calcutta on 31/10/2014, whereby it has been held that premises number 32 and 24/7 are completely two different premises. The plaintiffs are parties to the same, and as such, the same ought to have been disclosed by the plaintiff.
You are also saying these are two different premises.
But the High Court said it is two different premises.
So in this plaint also you are saying that only.
Yes.
So there is no conflict between the High Court. So
I say on the west or east, 32 is there.
Yes.
However, the same was deliberately not been disclosed by the plaintiff, and the same completely sets the case of the plaintiff had not. Photostat copy of the said order passed in such and such, copy of the relevant order, Lord. Here, Lord, I'll just pause here for a moment, Lord, whether Lord, the documents appended to an application under Order 7, Rule 11 or 151 can be looked into by the learned judge in disregard to, Lord, the settled principle of law. As Lord, in the event, Lord, it has been categorically said you cannot look beyond anything, even the statement in the written statements. So, Lord, the learned judge looked into, tried to find out a meaning, and Lord gave a finding that my plaint should be rejected at the threshold. Then, Lord,
Yes.
Then, Lord, they have used that magic word of fraud, that by perpetrated fraud by resorting to gross and deliberate suppression of material fact as such. And Lord, thereafter, Lord, the receiver appointed by the Honorable Court.
Yes.
And that it cannot be declared, Lord, void. Then, Lord,
24 by 7 not
then, Lord, paragraph 25.
Yes. Yes.
The instant plaint is thus a classic product of clever drafting, creating illusion of cause of action, which cannot be permitted in law to survive, as the same does not show and not disclose a clear right to sue. The plaint is camouflaged by clever drafting, and as such, this learned court has inherent power to see that such frivolous and vexatious litigation is not allowed to consume the time of the learned court.
These are issues, problems created by Arivan Dandan.
Yes, Lord, that's in 1976.
Krishna has created the problem and
77.
conveniently left the Supreme Court. Yes.
Nipped at the bud.
Nipped at the bud. Vexatious and
yes, vexatious.
Yes.
Then
the rest are the elaboration.
Lord, then Lord 151 CPC ex facie not maintainable for want of cause of action and should be nipped in the bud and all this, Lord. These are, Lord, the contention. So, Lord, coming back, Lord, I do not, Lord, take your Lordship to any other, Lord, the contents of the document, because that will at this stage, Lord, will not
counterproductive to your argument that we cannot look
one.
at.
Secondly, Lord, at this stage, Lord, if there is an observation about, Lord, the what are, Lord, the comparative, Lord, the merits of the content of the orders and all this, Lord, that will prejudice, Lord, eventually, Lord, if Lord, my suit survives. So, Lord, here coming back, Lord, to the order that has been passed by the learned judge, your Lordship has already seen, Lord, the learned judge in the decision portion. But after recording, Lord, the argument has, Lord, gone into, Lord, the contents of, Lord, that what the documents have been produced, appended to, Lord, the application and order 7 Rule 11, which the learned judge, in my respectful submission, could not have looked into. But I'll just take a moment, Lord.
Yes, yes, please.
Now, Lord, coming back to the decision with reasons, Lord, of the learned judge, but, that is about, Lord, the 4 pages.
Yes, yes.
Starting at, Lord, internal page 4 of the order. But first, the page 4, Lord, the learned judge has taken note of, Lord, the documents which are filed by, Lord, the defendant. Clearly says, on the other hand, the defendant have filed, Lord, and thereafter, Lord, gives a series of documents. The even a judgment also lagbe na judge sahib janen to.
Yes.
Then, Lord, second page, that is page 5, I have perused all the documents filed by both the parties to the suit. It appears the plaintiff did not disclose the matter of other suits where he was litigating parties in respect of the suit's scheduled properties. In the plaint, it is not disclosed how he gathered right and interest in the possession in respect of the scheduled property at premises number such and such. The judgment and degree passed in title suit number such and such, as it appears, show the subject matter strictly as premises number 32, which is not at all premises number 24 by 7 by 1. In this juncture, the version of defendant supports the allegation of suppression of material truth. But this is also jumping to a conclusion. In what manner? Why the learned judge says this? Because, my Lord, merely I have failed to, my Lord, disclose about the particulars of other litigation. They are free to, my Lord, say so in their written statement. Peruse the direction passed by Honorable Justice, passed in GA number such and such, which is submitted by the defendants, where the matter of report of the joint receiver is apparent. The joint receivers were directed to execute deed of conveyance for transfer of the entirety of the said premises being number such and such. I observe that the direction of delivery of possession is for premises number such and such and not for premises number such and such. So it is apparent that the plaintiffs have got possession in respect of premises number 32, Raja Santosh Road. The entirety of premises number 32 Raja Santosh Road is indicated in the order. Therefore, my lord, whether this order correctly reflects 32 or it should be 24/7/1, when all through, my lord, the case is being run out, that these are two separate property, and my lord,
What
somebody
was the
was seeking.
context? You have not clarified in your plaint the context of mentioning the history of 32.
True, my lord, there is something which has
to
not been
deduce.
spoken of, but whether, my lord, that was necessary in the, my lord, the framing of the suit. Because I have not asked for declaration of my title.
Even
Therefore,
if you mention superfluous facts in the plaint, we are taking the extreme, whether it can entail a rejection of your plaint.
but in my respectful submission, my lord, no, because, my lord, for this facts, my lord, this can always be brought forth by the defendant in the written statement. If at all, my lord, in particular cases, my lord, it can be decided by way of Order 14 Rule 2.
Suppose we can't understand the connect between 32 and 24, even then, we have to see whether your chain of events of cause of action has been disclosed. You say you have purchased a portion of 24/7 by 7.
I'm in possession, I'm mutated,
Part possession, part purchased. Then you say, as per your strictly going by your plaint case, within bracket 24/7 has become 24/7/1, and that they have put in guards just outside the premises trying to disturb you in ingress and egress. So you file a suit for declaration of your possession and restraining injunction order protecting that. So here, whether these considerations of another suit being pending or the other things, I mean, non-disclosure of cause of action is not there. Quality of cause of action cannot be looked into at the Order 7 Rule 11 stage. And suppression, whether that is germane, for that also you are arguing that we have to look at the plaint, the scope of the different suits, and take evidence. So at this stage, it cannot be.
That is.
Yes.
And the learned judge is finding, blood one by one, blood, as your lordship has seen. But
32 and 24/7/1 are different properties. That has been highlighted by the learned judge, but you never say
even
that.
admitted by them in the Order 7 Rule 11.
No, court is on that premise. Court is saying as if you are claiming both to be one.
Yes.
That you have never claimed.
Then, Lord,
Rather the contrary.
I'm grateful to your lordship, Lord, that your lordship will find, Lord, at page 5, last 3 lines, the learned judge says.
Yes, we are looking at that. That in this order, I observed that the direction of delivery of possession is for premises number 32 and not 24/7. So it is apparent that you have got possession in respect of. Now we can't understand this. It is apparent that the plaintiffs, plaintiffs have got possession in respect of. No, you are the plaintiff.
I'm the plaintiff here.
So you have never stated that you have got possession in respect of 32/32.
They are trying to take help of, Lord, that the sale deed that was not executed.
That was the plaintiffs in that suit.
Yes.
Not this.
That was trying to, Lord, they are trying to, Lord, indicate that.
So you have stated that defendants in that suit, the plaintiffs in that suit purchased the property. Subsequently, you have also stated defendants in this suit were substituted in place of the plaintiffs. So defendants in this suit have become owners of 32 Santosh Rai Road. That you have stated in your plaint. But here it is observed, it is apparent that the plaintiffs have got possession in respect of 32.
Lordship.
We can't understand this statement.
Lordship. Not the last 3 lines. The present plaintiff have nothing to show that any further survey commission was done to show that premises number 24/7/1 is part and parcel of premises number 32.
Contrary to your case. Your case is that not. It is not a part and parcel.
It is not at all. And the learned judges, Lord, one of the reasons for, Lord, allowing the application is this.
And also goes on to say Justice Tandon's order that
Lordship
32 and 24/7 are different. Which
Lordship.
you are also not disputing. I mean,
I'm not disputing.
At least from the plaint.
Then, Lord, comes to, Lord, page 6, Lord, the last paragraph. The defendants have filed document relating to land acquisition. In respect
the court
of
disregards.
these are all, Lord.
The court says there is no reason to enter into the same. As no point. Court says that. That is not taken.
Then, Lord, the next
one is suits, 2 suits, that is relevant. That we are also just thinking on that.
Lordship.
2 suits by Mr. Pawani, Bijoy Pawani. One is claiming joint possession. Another is another was mentioned in there.
One is for partition.
One is for partition. Another for
challenging the sale deed. My learned friend can blood it.
Title suit number 39, Milord. Title suit number 39 of 2013 by the suit, Milord.
Yes.
The Pawani has challenged the purported deed which was executed by the order of this honorable court.
In favor of whom? Them.
In favor of them.
Achha.
The the original, my lord, original Vijay
Do not go
Rajpuria
into
was
details. So
yeah,
challenges their deed.
their
That
deed
court sale.
in the courts. There is pending.
And the other
is the partition suit in respect of 311, which I'm possessing.
311?
Yes, 311 square meter. That yes, that I have purchased 1200 square meter
Right.
and 311 I'm possessing. My lord.
That is title 17.
No, title 17 is their suit. That is 63 of 1990 partition suit.
Right.
Partition suit, and there's the other suit is challenging the purported deed, my lord. They filed the orders and volume application that is rejected. Now they prefer an appeal.
Yes. Thank you.
Now, my lord, at page my lord, 2, that is internal page my lord, 7.
Yes.
Next, I would like to come to the point of cause of action. In this regard, I observe that the plaintiff have brought the cause of action in this way that the defendant are denying the title of the plaintiffs. And they are disturbing peaceful possession of the plaintiff. The second party is not correct, the first party is wrong. On careful perusal of the entire plaint, I find no act of such challenge on the part of the defendant. The cause of action does not indicate any single sentence, but it is togethering the facts, not such and such. The cause of action disclosed here is not properly framed. The cause of action is to be taken which gives the plaintiff the right to relief against the defendant. Every fact which is necessary for the plaintiff to prove to enable him to get a decree should be set out in clear terms. The cause of action must include some act done by the defendant, since in the absence of such an act, no cause of action can possibly accrue. Law does not permit a person to get relief in respect
Yes,
of
Mr.
property
Mukherjee,
which is
we have seen.
others have not much.
Others we have placed already, in fact. Disclosure of course.
Yes.
Now,
And
if you want to cite anything, or you rely on those judgments that only the plaint and the documents relied on can be looked at. 2006 you have cited in the trial court.
No. Dahivene judgment দাও এগুলো 226 এ maintainability judgment কে দিয়েছে সংসুদা not disputed proposition not a disputed citing can cite no lord it is not lord your lordship knows lord, and I don't want to cite this judgment lord 226 suppression and all this thing judgment lord. The evidence is not clear. Plaint and documents appended to the plaint. Look no further. You looked into the documents, filed
The doctor may be citing one or two judgments which where it has been a bit widened. So if he cites, then he will.
Lord, I'll give it in But I am a stopgap counsel, Lord. Mr. Basu was addressing your lordship here. This matter.
Stopgap has.
Now I
filled
don't know.
in
He
the
might
entire gap.
come tomorrow and take over. He's now Lord in a.
We won't permit him.
Circuit bench.
Yes, Mr. Datta. Mr. Basu wouldn't have cited those judgments also. Yes.
Oh, the argument should Yes, no, Lord. He says that he was told to carry this judgment.
By Mr. Basu. How many judgments?
Not only one.
You cite it. Mr. Datta, let him cite. If you are convinced, you cite. Mr. Okay. Then don't.
226 maintainability and all this thing, Lord. But maybe he was carrying it because Lord, he was anticipating some Lord.
No, Mr. Basu carries judgments for several courts together, so we don't never know. I mean, might have been exchanged to some other court. Yes, Mr. Datta. So that proposition is more or less settled. That into the yes. So Banerjee may have a different take on this.
Because he always
Mr. Banerjee prompted by others. Yes.
He is a classic example that the law should be dynamic.
Yes.
But here, Millard, here, Millard, I think Millard, there is an issue, Millard, which I must candidly say before I start that the point that was canvassed could have been much easier and more simply said than what has been attempted to be said in the judgment. But Millard, the crux of the matter is, Millard, is this. Millard, permit me to say this. If I am declared this to be the owner and in possession, in a suit between me and my learned friend's client, any subsequent attempt to show that I have a right within this Millard is barred. That's the crux. And that is exactly what has happened.
That is why, my lord, your lordship is, my lord, trying to understand if two premises are different and the parties are not saying the premises are different, then where is the fight? The fight is this, my lord. Your lordship will find that in the plain, my learned friend seeks declaration and possession. To seek a declaration and possession, my lord, he need not refer to any other decree in the suit, but he refers to. When he refers to a decree and annexes the decree, my lord, then that decree has some sort of interpretation to be given to, according to him in the plaint also. Now, what he does, my lord, is this. If I may just show 4 paragraphs from the plaint. My lord, while my lord saying that I purchased this property in 2 pieces, one from some gentleman, the other, let's take it, he is in forcible possession, my lord. All of a sudden, in paragraph 8 at page 184, he comes up with a decree. On or about 20th September 1989, one Jyoti Kumar Rajgaria instituted a suit in title suit number 54 of 89, which was subsequently renumbered as title suit number 17 of 2002 in the court of the learned civil judge senior division 9 court at Alipur against the plaintiffs in this suit and the appellants for a declaration of the plaintiff's right, title, and ownership in respect of the suit premises, khas possession thereof, perpetual injunction restraining the defendants from transferring any part of the suit premises in respect of premises number 32 Raja Santosh Road, mandatory injunction restraining the defendants from pulling down the structure, injunction, receiver costs, such further under other reliefs. Then, my lord, some proceedings are discussed. My lordship need not go, come to paragraph 10 straight away. The plaintiffs in that suit contended that the defendants and their main agents, servants wrongfully trespassed into the same land belonging to the plaintiffs in that suit meaning the Rajgaria's suit,
Yes.
as the same was part of premises number 32 so and so, and the plaintiff in that suit sought to recover the khas possession from the defendants in that suit, who according to the plaintiffs of the suit were encroachers and trespassers. The defendants in that suit denied the description of the suit property in the schedule to the plaint. Denied the description of the suit property in the schedule to the plaint was correct. And the plaintiff in that suit was dishonestly trying to include the defendant's property by falsely claiming to be the part of the plaintiff's property. And the story of trespass and encroachment was totally false. In that suit, he is argued this.
Apparently, 24 was sought to be included in 32 in that
Yes.
suit by Rajghoria.
And that is what he defended over there.
Yes.
That was an issue in that suit. Thereafter, my lord, kindly come to 13. The suit, my lord, ultimately the suit was tried and 2 issues along with other issues were specifically framed in the suit, namely, did the defendant trespass into the suit property and are the plaintiffs entitled to recover possession? Both the issues were decided against the plaintiffs in that suit, and it was held that the plaintiffs failed to prove the encroachment and the plaintiffs were not entitled to decree of khas possession as claimed in the suit. The suit was decreed partly in favor of the plaintiffs to the extent that they were entitled to a declaration of their title in the suit property, being 32 Raja Santosh Road of that suit. The said suit was decreed on 14th. A copy of the said judgment and decree is annexed here to mark with the letter A. So, for decree is part of the plaint. May not kindly take the decree once. Ask. Kindly will not take the decreter.
Judgment.
It is not annexed to the petition. I'm saying. Decreter. Judgment. Millard, at the end, Millard, I shall come to the judgment. You need be kind.
It is a part of the plaint, Mr.
Yes.
But you have not annexed it here, maybe due to the bulk. It was annexure to annexure to the plaint.
Yes, that was blood. But maybe in that.
Yes.
I don't ascribe any. Blood, I can hand over the plaint that as filed. This was the plaint as filed. It as filed. So as filed, I can.
So the judgment was filed. You have annexed copy of the said judgment and decree of the suit.
there. It is there.
It is there.
This is the complete copy. So এটাকে লাগাওনি কেন?
ওটা certified copy তো দেয়নি
So you have to give copies to the whether these tallies we don't know. This is a certified copy of that suit.
আমরা তো প্লেনটা গোটা প্লেনটা
গোটা প্লেনটা দিলাম প্লেনটা অ্যানেক্স আছে
হ্যাঁ গোটা প্লেনটা তুলে
The entire has not been
yes the decree is there and
the
the part is there
judgment is also there.
Judgment and decree both are annex.
I take it to be both.
Anyway, yes.
What's up place? Everything is there.
Yes, exactly same.
But why should it be different? I don't ascribe any reason. Maybe not it's
No, you are not in control of what you're getting. Even your learned friends are not in control. I mean, whatever is given to you, you are citing.
Very well.
So we have,
come any.
at the end of the day, you are passing the judgment, so we have to look at that.
I'm sorry, I stand corrected.
No, you should not be sorry. So I will see either, yes.
Either.
You have given a copy, we'll take your copy. You gave first. Yes, you say that. Yes. But the pages also tally actually.
Yes,
it's a typed copy.
The decree in original, kindly come to the decree.
Yes.
Kindly turn over the page, Millard, at page 2 of the decree. After
Decree or judgment? The judgment.
Decree.
So we are interested in looking into whether this identity of 32 and 24 was an issue there.
Absolutely an issue there.
Because it's obvious from there. That is what it says.
That
yes.
is what it says.
Yes. Let us see the decree very well.
The suit B and the same is decreed in part on contest as against the defendants. The plaintiffs have right, title, and interest in respect of the suit property. Then Millard kindly come to Schedule A in the plaint, referred to in the plaint. Then let's go to Schedule B in the plaint.
But 24/7 is not there.
That is there on the side. That is the original one.
So partly by vacant plot, no. On the south, it's there.
That need not, because that's the unamended. I'll show the plaint. The decree is in respect of Schedule B. Kindly come to next page. Schedule B referred to in the plaint.
Yes.
Southwestern portion of premises number 32 Raja Santosh Road, such and such, such and such, such and such.
Yes.
On the north by premises number 30, so and so remaining.
South 24/7 is there.
South 24/7 Raja Santosh Road, as delineated in the map or plan annexure B. Annexure B to the plaint is at page 68. But for that moment, Millard, if your lordship, Millard, sees this and the page 193, I shall come to the schedule. Page 193, your lordship has a schedule.
Yes.
Current plane.
Yes.
Kindly match the two schedules. The boundary. I'm sorry, that schedule.
But these are different.
No.
Why do you say that?
Boundaries.
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 Achha.
On the north by 30, here also, according to the plaintiff, his property is on the north by 30. On the east, premises number 32, he says 32. 32 was later renumbered by 32A, and I'll show that from the.
But he has disclosed this plaint.
So
he has disclosed.
Lord, if I get a declaration on the basis of this schedule,
yes,
how can he file a suit on the basis of the same schedule claiming the same declaration? And this suit is, Millard, between the same parties.
Yes.
And where, Millard, this issue was raised at the time. That's the crux.
Boundary is just somewhat
not only is
very minor.
Millard, if your lordship comes to the plane, there is a map. Your lordship will find a map here.
Yes. In the decree.
In the map. Kindly take the map.
Map is
It's annexed to my plane.
map or the proposal to do. Yes, it's there in Mr. Mukherjee's copy.
Millard, the prayer in the plane,
Yes.
the previous suit, your lordship, it's not legible.
Not
Decree for declaration of plaintiffs, decree for khas possession of the suit premises described in the site plan marked Schedule B comprising portion of the lawn on the southeastern portion, the main land building premises number 32. I got a decree in terms of Schedule B. Now, Millard, Schedule B map, Millard, if your lordship sees, and the map which the plaintiff has annexed in this suit, Millard, if your lordship sees, is the same property.
detailed map.
ওটা পরে আসছে।
no, there was a map in that decree also.
Yes, at the last minute, I'm sorry.
No, that is also here. No, only one map we find from the plane. They have annexed this map which there's and they have annexed is a that is a part of the decree.
Part of the decree.
Yes, but this was annexed as a part of the decree club.
Yes, this is also part of the decree.
So this is the this map. They admit that this map is a part of the previous decree.
Yes, yes.
Yes.
Because Millard, this map and
Yes.
the decree,
Yes.
Millard, indicates
Lord,
which
that is X, Lord, that is a separate site map. I've stated here, copy of the site plan of the said property.
X. Yes,
What your lordship looks at.
Yes.
yes, that's X. I'm showing X only.
Yes. That is not part of the decree.
It's X.
That is
Not a
only-
part of the
no, no. Lord, I only indicate that which property is not the subject matter of litigation in the present suit.
Where have you referred to X in your plane?
Yes, Lord, we have in the, I'll show, Lord, in the body of the plaint I've referred to.
কোথায় X দেখলাম
Yes, that is the A.
Para four, para four.
But in the schedule to his plaint, Millard, he says
Yes,
that
Lord,
Not
para
X.
4. Para 4, yes.
X.
Para 4 refers to X.
Yeah, the said property delineated in the map or plan attached here to and marked X.
Yes.
The remaining code, the said property delineated. X is according to you your property.
Yes.
Yes.
And I'm
Your entire property.
Yes.
Subject matter of Lord, this particular.
So I'm saying showing X is what was in the previous suit, the same plan.
On the last order, your lordship has recorded that Mr. Dutt was not supposed to produce the map.
That is what I'm doing.
কিন্তু আমাদের তো কপি দিসনি তো।
Copy the only-
It's a different map.
Yes, yes.
Now we are looking at your map.
That is appended to the plaint X.
Look at that. Look at that. And I'm showing the map which is annexed to the degree.
That we are not finding. Where is it?
Millard, that is there, Millard, with along with the big plate.
No. In your copy also it's not there.
আগের ভাই অর্ডারে
Neither in your copy nor in his copy there is any other map.
Plaint
Decree does not say that any map is a part of the decree.
No,
Mr.
Millard, I'll come to that. If that is your lordship,
Decree has to say that the map is made a part of the decree.
I have a certified copy of the plane.
Map was a part of the plane, not a part of the previous decree.
Decree also.
Decree does not refer to any plan.
Decree does.
Partition degree
Oh,
Decree does.
Mark B.
Yes.
But this is not marked B. I mean, we don't have that. That is not annexed anywhere. That B is not annexed anywhere. Is it a your copy also does not have it? Your copy of certified copy of the previous judgment.
Millard, my certified copy of the decree refers to
Schedule B above
Schedule
in
B
the-
referred to in the plane at the lordship at the top your lordship finds. Schedule B above referred to in
Yes, it refers to B,
and thereafter
but the map is not there. The actual map is not there.
map is delineated in the mentioned as B in the plane.
No, plane refers to their property as X.
My
And this
plane,
is
my plane in that suit. Your lordship is looking at the current suit.
Yes, but we don't see that map anywhere. That is what we are saying. And then we have to look into the plaint of that suit also.
Yes, I've obtained the
But
certified
you may broadly argue that because that map B has been referred to in the decree which has been annexed by them.
Yes. And Millard, my plane refers to that.
This has to be looked into as
No,
evidence.
Millard,
Mr.
with
Das.
respect.
With
with
at the
respect.
order 7 rule 11 stage, we have to look into whether we don't have that map with the plane.
Millard?
That plan marked B, we don't have B as a part of the decree.
Milord, my learned friend relies on a decree. The decree refers to the map.
Map is not a part of the plaint, nor have you produced them.
Map is part of the plaint. Definitely, plaint ka down.
It does not say that. It says Schedule B above referred to in the, oh, sorry, in the plaint.
Plaint. And
Yes,
plaint.
yes, you are right. You are right.
Milord, this is the plaint.
Let us see the plaint.
Piecemeal kagaz dewa jabe na.
No, plaint. Where is the map?
76,
Map number.
77. Kindly, Milord,
A copy language.
kindly, Milord, come to this paragraph.
We require more copies. Mr.
Kindly, Milord, come to this paragraph. I'll give you.
If you have to sit and compare the maps, Mr. That definitely
No.
it has to be relegated to evidence.
If it is to be
If the order 7 will evidence, then no court is supposed to
no,
do.
Milord, the thing is this, Milord. If I have to,
We have to compare the maps, and we don't know whether these maps are identical.
Milord, it's according to the plaintiff's disclosure of boundaries, it's identical.
It looks to be identical. The shape is.
But it's as per the description in the schedule to be identical. You have to take the plaint as correct.
So, but this then what do you say? Res judicata then? It's a new ground you're taking for the first time here.
Circumvent the decree.
Milord, circumventing a decree is, Milord, what I'm trying to say. What has been finally adjudicated between.
They disclose the decree. The effect of that has to be looked into by the court at the time of trial.
So, Milord, what they did is, Milord, is very thing. They have disclosed the map. They have disclosed the decree. Now, kindly see the plan that they have annexed to their plaint. What they do is, Milord, within that 32,
Similar.
within that, Milord.
So you are saying basically that they have lost a suit. Rajghuria got a decree in respect of the self-same property as 32.
As 32.
Now they're trying to portray that as 24/7/1 and to get a new decree on that, which is barred by res judicata, basically circumventing a decree.
And they have not preferred an appeal from that. They have accepted the decree and they have relied on the decree in the plaint.
So whether very well.
It is binding on us.
So then,
and he takes a cue of that decree and say that I have been declared as the owner of 32. And what he shows as 24/7 is 32.
The other grounds in the order are.
Milord, as I told you, Lordship, Milord, a very simple thing, Milord, could have been said in a very simple way, but it gets convoluted. And other grounds, Milord, I am not satisfied, so I am not pressed yet.
Let us confront Mr. Mukherjee with this.
Okay, but that's
two things.
That's it.
Yes.
This is no more trial. This is again finally, and
Have you got a copy of this map, Mr. Mukherjee, the other map, part of the decree?
No, I did not. But
Look at the map, just see it laterally and look at your map.
no, Lord, prior to that, Lord, the Lordship will kindly take Lord, page 82 of Lord, the compilation that my learned friend or
Can one.
can one.
I'll just have some water and come.
Yes, please. You can have Mr. Mukherjee's water also, unless something
But
else
I
is
just Lord,
mixed in it.
you finished it. I finished. I can ask my clerk.
Well, he didn't know that you would drink. Come on. Don't embarrass him. Yes, which page, Mr. Mukherjee?
Lord, page 82, Lord.
82. গিরিশগুপ্ত judgment, দেখলেই ভালো।
পেজ ক্যান আমাদের ক্যানের তোর এটা 82 পেজ 82
চ্যালেঞ্জ দেখেছেন মালগুড়ি কত বুঝতে Yes.
Your Lordship will kindly come to Lord. The question about Lord, the identity of the two properties were Lord, the subject matter of a civil revision in this before this honorable court.
This arose out of which suit?
Lord, Lord, that 54 of 1989. Smita Srivastav was a Jyoti Kumar Rajgaria at the top.
Yes.
On one hand, he says you can't rely on these orders and orders.
No, when my learned friend is
So this is
relying
a part of the plaint.
No, it is not part of the. Nothing is a part of the plaint. But the part of the plaint is only Lord, the previous
You have
degree.
referred to this order
No,
in the plaint.
no, I have not. Because I am counteracting
But you
my
have
learned
referred-
friend's contention.
You have referred to judgment and decree passed in 17. And judgment and decree refers to Schedule B. So therefore, they are entitled to show us Schedule B.
Yes,
But this
but
is
Lord,
something which
what
is not
they are also
reported.
Lord, should Lord point out before your Lordship about Lord the description, Lord, there was an amendment which was Lord subject matter of challenge in the civil revision. And the observation of the Honorable.
No, this is not the last amended. The decree must depict the last amendment.
I will just show Lord what the Honorable Court said about that. But at page 82, Mr. Khanna, learned counsel appearing for the defendant petitioner submitted that the proposed amendment to Schedule B to the plaintiff was seeking to lay claim in respect of the property being premises number 24/7/1. Raja Santosh Road, Kolkata, which according to him is a property belonging to his clients. He submitted that the fact that this property belonged to his client was not also disputed by the plaintiff, and it would appear from Schedule B originally appended to the plaint that premises number 24/7/1 Raja Santosh Road is stated to be situated in the west of the property sought to be recovered. He therefore submitted that no part of premises number 24/7/1 Raja Santosh Road was part of the suit property, and by the amendment, a mischievous attempt is made to rope in the aforesaid property, namely premises number 24/7/1 Raja Santosh Road within the suit property sought to be recovered. Number here, real game is coming out.
What was the amendment?
Not that they are trying to incorporate my client's property to be part of 32.
So the schedule was also amended.
Yes, the Schedule B. Then kindly see how not the Honorable Court dealt with that. This court is not impressed by the submission of Mr. Khanna because the property sought to be recovered is premises number 32 Raja Santosh Road, Calcutta 27. Even assuming that any mischievous attempt was made by the plaintiff by the proposed amendment to rope in or to involve the premises number 24/7/1 Raja Santosh Road within the ambit of the property sought to be recovered, the original schedule shall continue to remain binding upon the plaintiff as an admission, and the defendants are entitled to take benefit thereof in accordance with law.
What does this mean?
It means that even if you have amended the original the original contention in the plaint, that will be binding on the plaintiff. And original plaint schedule is at page 77. That was by Rajgaria. The taking advantage of lot of mischievous amendment, but they are showing before your lordship a decree.
The original schedule shall, how does it continue to remain binding on the plaintiff if it is amended?
Because Lord, in the main schedule at page 77, they have given Lord the correct description of the property. By amendment of Schedule B, they are trying to Lord put in Lord my client's property as
but
32.
they are no longer bound by the original schedule if the schedule is amended.
But that is what Lord has been corrected by Lord.
The next sentence, it says, the order says, needless to mention, it will be open to the plaintiffs.
Yes.
Prove that the statement made in original Schedule B was made by mistake.
Lord, they failed to prove. They could not get possession. Where that is not the degree that I have appended.
We'll have to look into the.
They could not.
We'll have to look into the judgment also.
Yes. Then your lordship will find the judgment and degree that I have not annexed along with the plaint.
Judgment. প্রথমে ঠিক কথা খুলে গেছে
the stay petition has the unamended claim, not the amended claim.
Because of the order passed by this honorable court.
The amendment was not interfered with. Was not interfered with.
No, but Lord, it said that the intention of Lord
that will remain binding, but I am not interfering with the amendment order. So amendment has been effected.
We have a right to challenge, and that was not challenged.
The statement in the plain paragraph 16 says, as the plaintiff is awarded the aforesaid judgment and decree of 14th is in full force, the same is binding on the parties here too.
Then in Lord, the second suit, Lord, they could not get back possession on the strength of the paper decree.
I am in possession.
I mean, the declaration. Decree says I am in possession.
No, not at all.
Kindly see the decree, it says I am in possession.
Issue number 4 and 6.
Issue number 5.
Under 134.
134.
The encroachment cannot be proved. Yes, it says I am in possession. The local will more the encroachment cannot be proved by mere. The local investigation would be more appropriate to bring a clear picture of the encroachment. PW1 stated that the suit property is at 32 Raja was surrounded by boundary wall, having a gate for ingress and egress to and from the property. Therefore, there is sufficient doubt as regards the alleged encroachment. That is the finding, that within 32 there is no encroachment because you are
Then enter case and recovery position. In that case, then recovery position.
Mr. Mukherjee, the previous judgment that says,
Lordship,
just before issue numbers 5 and 6, we don't have the pagination here. The identity of the suit property as 32 Santosh Rai Road has been well established from the documents available.
Lordship.
Now the description is in the plain, read with that map, which was referred to in the decree. Now that description, if the description is exactly identical with your suit property, which you are now portraying as 24/7/1, is that not vexatious and should be nipped in the bud?
But that until unless there is a local inspection commission or a local investigation commission.
But identity was in consideration before that court also, because you took up specific point before the divisional court also have shown, and that 24/1 by the amendment they're trying to bring in 24. The amendment was not interfered with. Justice Gupta was pleased to observe that it will be binding on them, but they'll be entitled to explain. Now, whatever explanation they have furnished, we don't know, but ultimately the decree is passed saying that identity and the amended schedule is taken into consideration, and it has been said they have established their position in respect of that.
But in the second the suit, they could not recover possession.
The main suit. Recovered a person on a different ground, on the contrary ground, that they were never dispossessed.
Lordship.
They could not prove their dispossession. That's why recovered a person was held redundant.
Lordship.
Because their position was established in respect of
yes.
For the self-same property, you are now just defining it as you change the name of the number of the property, and you in the schedule you put the self-same property, which has been it already has a decree in its name. Saying their position.
So far as
vexatious.
May I just indicate? Suppose your lordship is comparing it with the boundaries of the previous amended suit along with the boundaries of the present suit,
and the map also your X along with that map B.
Kindly as of now don't look into that the maps. Suppose my plane did not contain any map,
then its position would be different.
Yes.
But then also the boundaries are similar.
Then this is a question.
The boundaries.
The boundaries, there has been a changes, this is gives rise to not a
something here.
Yes, but that is a tribal issue. Either I succeed on the basis of my plane or I fail.
Otherwise it would be tribal. But if you rely on a particular, you mention 32, a decree about passed on 32, and you say this issue was raised regarding 32 or 24, whether they are the same, and court ultimately holds on the definition of that on that suit property, which was the amended suit property, that this is 32, this belongs to X. Now you are Y. You are coming up and saying same property, you are changing the name and saying declare this to be mine, me to be in possession. So that is exactly because you are a party to the previous suit also. It's exactly contrary to that suit. It's palpably barred by res judicata. Even if you look at your plaint pleadings and your annexures to the plaint, the judgment boundaries and the map.
Very well. Even if I'm take it, it is a res judicata, that is also going back to the court below for a
no, it's on the face of it then. The self-same property description is exactly same.
That this particular document which my learned friend relies upon was not before the court by you of an evidence.
Your plaint.
My plaint has to be compared with what my learned friend is relying upon. That was not before the court, and court could not have done
so. We are not looking into that document, Mr. Mukherjee.
But so far as
your plaint, we are looking at your plaint schedule. The annexure to your plaint being the judgment and decree passed in 17.
Lordship.
That judgment and decree gives a description, gives a schedule.
Lordship.
Your plaint has a schedule. Both belong to your plaint and annexures to your plaint.
Lordship.
We look at the two schedules. Seem to be exact same property, boundaries same, but you name it differently. One. Secondly, your plaint's annexure X and your plaint's annexure of that decree, which refers to B. We are looking into B. You have not given B here. Must have been a part of the trial courts, I mean, because it refers to B. If it is not, he's handing over, Mr. Dutt is handing over the plaint of that, which has been referred to in that decree. So if it has referred to in a document referred to by you,
Lordship.
then we can look into it. To
Lord,
nip in the bud this, I mean,
possibly,
mischievous-
my lord, at this stage, my lord, this should not be, because this is my lord, a question which has to be gone into by the court, my lord, as to the identity of the exact property. But your lordship is going by the description, my lord, contained in
Your
the my lord.
description.
Yes, my description. But my lord, so far as my lord, your lordship is saying that my lord, it covers by the previous decree. But the previous degree and my lord, the description of the property, that does not lord identical or lord tallies in toto. There are lord certain differences between the two.
Just see the differences.
The original print 100. 101. 101 যে ফাইন্ডিং নিয়েছে DS 17 কিছু যে ফাইন্ডিং
না না ওইটা নিয়ে কথা হচ্ছে না
দেখো ওটা এখনকার প্রিন্টটা দেখি
যে অ্যামেন্ডেড প্লেনটা আছে অ্যামেন্ডেড প্লেনটা বাইন্ডিং আমরা যারা এটাই আমি ক্লেম করছি 32 by 1 সেটাই করতে
we are looking at that the schedule given in the plaint of the earlier suit or the decree decree of the previous suit and your schedule at page 193.
Lord, I do not have the plaint of lord the
Let us please look at the decree of that previous suit.
Yes,
You'll find it
Lord,
there. Schedule B.
No,
this is the decree of the earlier
Lord,
suit.
We have a copy.
May I just not take back lord the
Yes.
entirety of the plaint that I handed over to your lordship?
Yes. Yes. But we don't, then we won't have X.
That is not that. Lord, something.
The other one?
Lord, oh, it. Yes.
But we want the X back.
Finding doesn't take it to you have finding needs.
You cannot mask the X. On the north, on the portions of 30, which the remaining part.
Now, Lord, page 44, that is what, Lord, the schedule B. But page 45. Schedule B that is referred to. Now your lordship will kindly come to Lord.
14.
Where?
Page.
We don't have the. Can you just calculate somewhere in some calculator whether 1534.385 square meter correlates with 1 bigha 1 kata 5 chatags? I don't know the exact.
He will be in a better position.
Conversion.
18 kata something.
Do the areas tally?
Into divided by 720 into
স্কয়ার মিটারটা দেখতে হবে
বাদ দিয়ে না এটা বাদ দিয়ে
একটু একটু চেঞ্জ আছে ওর 32 টা কেটে 32A করে দিয়েছিল
32A
32 becomes 32A
32 become no 32
in your property
becomes 32 in my this
yes
is not,
becomes 32 right
yes.
32A becomes 30
yeah.
And this north is premises number 30 in the previous one 30 and remaining part of 32
lordship
and yours is
no on the south premises number 24/7 Raja Santosh Road and premises number 13 and 14 Alipur Avenue and that is 13 Alipur Avenue here. And on the west by premises number 14 Alipur Avenue and portions of 30
west
Raja
is exactly same. Oh no. Yes, exactly same. West
yes.
is exactly same.
Yes.
West exactly same.
And the south is not the same. South is not and 14 Alipur Avenue is not there. And 32A Raja Santosh Road is not 30 Raja Santosh Road. But the area is there. The western portion of the premises number 32. That is not, it says southwestern portion. The southwestern portion, premises number 32 Raja Santosh Road, measuring such and such, such and such.
Southwestern?
No, it is southwestern ito tai lekha ache.
কোথায়
Southwestern ito. But that first,
That do you find southwestern?
but the first
Schedule B.
western schedule B above referred to in the plain. Then
Oh,
what-
it starts with that. We thought the boundary.
southwestern.
Oh, acha.
Southwestern portion of premises number 32. So
Yes,
this is
but
not they refer
we are
to
looking
not-
at the boundaries. The boundary, whatever you,
that is not out of 32. They talk about not the southwestern portion.
but the boundaries on four sides are given, which more or less tally with your boundary.
Yes.
Together with
Not-
21,
not-
21 square
No,
foot passage is
some
not
difference is there. In the north,
The passage is not there. The 21 feet wide passage in connection, that is not there. That is in my suit. The big properties are carved out, not, and thereafter, not the smaller properties are created.
Horizontal, that's the same thing. Keep it horizontal, it's the same thing.
But this not has to be not gone into by the trial court whether not I am talking about the same property that there was a previous degree, or Milord, there is something Milord for me to Milord prove with reference to my purchase deed.
And
By purchase deed, something has been purchased.
page 50, page 50.
That cannot evaporate.
Page 50 is the page 50 of the can one amount line that was DD. Page 50.
we are more or less of the view, Mr. that it will be probably a bit too much to do it in order 7 rule 11. At
At
least
page
electoral
50,
investigation
Milord, my
was necessary.
deed plan is
To
there.
see the identity of the suit premises. It can be taken as the first issue in the suit. 7-11, it will be a bit difficult. I mean, 7-11 has to be at the first blush.
7-11 is not, Milord, what A or D or C or D. It will come if your lordship looks at it as a vexatious attempt to, Milord, re-agitate an issue.
Whether they're re-agitating for that,
Kindly
you have
see,
to
Milord, Section
identity.
12 once, Milord, Section 12 once.
Look, we have to identify whether
No,
these.
Milord, the cause of action. Cause of action, what is this cause of action?
No, there is no non-disclosure of cause of action.
No, I'm not on that. If I may be
If there is non-disclosure, only then it can. Oh, you say the cause of action is vexatious. Why do you say that?
Because if
You have to establish that identity of the. You have to establish the identity of the two suit properties. Then
Milord, the reason I say so is because of 3 statements in the plaint. One statement in the plaint is that there was a boundary dispute which has been settled in that suit.
yes,
A. B is that decree is binding on both the plaintiff and the defendant in this suit.
Failed to obtain poison.
And 3 is my learned friend says that by virtue of that suit, Milord, as the plaintiff did not get anything, I on the contrary also got a declaration that I am the owner of.
no, he does not say that.
Yes.
I'm possessive. I'm possessive.
He says that you got a declaration that regarding 32.
I missed that.
What is that portion?
Purchase that dolichta দেখা যায় ওটা দেখিয়ে দেবো Purchase
Where do they say that?
But and also not the purchase deed, the map annexed to my purchase deed.
Go that far because of your.
That is
statement.
also relevant. Since we
Plan
are
is there.
not trying to find out the
It's a part
exact,
of the plaint.
it is a no,
But
part
with
of
the
the
plaint.
plaint না, but part of the injunction application. We sell deed টা ওখানে injunction এ লাগিয়েছি। Injunction এ লাগিয়েছি।
So you have referred to the said lead in the
Yes,
plaint.
yes,
Then we can
referred,
look
the
into
deed
the
is
case.
referred.
By the same
Deed is
logic that we can look into B.
Paragraph 14, if your lordship sees just after
Deed is
he
referred.
annexes the decree, it was established in that suit
Yes.
that the plaintiffs in this suit
Yes. Never
never
trespassed or
trespassed or encroached on anybody's property, and it was established that they have all material times remained and still remain in lawful and absolute possession of 24/7/1.
This is superfluous. This was not established in that suit.
Then thereafter, Milord, kindly come to.
So, but that does not entail a rejection of the plaint for saying these extra things.
No, what I'm trying to say is this, Milord. So, and paragraph 16, last line.
Yes. They rely on that.
So Milord, as a
They rely on that, do not suppress it. They produce it before the court also, including the judgment.
So, and Milord, so therefore, in spite of doing all this, Milord, ultimately the relief that he claims is declaration that.
Yes, but at the end of the day, whatever you are arguing, Mr. Dutt, leads to this, leads to us to inquire into whether these two properties are identical. If they are identical, exactly identical, then you are absolutely right. Because they themselves admit that parties are bound by the previous decree. If the properties are exactly identical, then their suit is palpably barred by. This is one of the rare cases where res judicata is admitted. It will be that.
Yes.
Because they say both sides are bound.
Yes.
But there, even if there is a slightest doubt and we feel that local investigation is necessary to ascertain whether these two properties are similar, that would be the first issue in the suit. But 7-Eleven, at a visual glance, we cannot say that. Because you see, East, premises number 32, they say. Now, your East was previously 32, you make it 32 capital A.
32 capital A because Millard, there has been a portion sold and
This because we have to look into why, because whether these are the same or not.
32. He is not claiming a right on 32. And 32.
Boundary, we are speaking of the boundaries.
So
the boundaries are not exactly identical. That is what
but
we are saying.
Millard, his claim does not also say 32. He says 32A. He says 32.
No, he's plain on the east, the eastern boundary is 32.
He says 32.
And your eastern boundary is 32A.
32A. But that is only the boundary.
See, you are on the boundaries only. Apart from the boundaries, how do you ascertain that these two?
Correct.
Achha, the north is there, north is by Raja Santosh Roy Road and portions of premises number 30. Yes. You say premises number 30 and remaining part of premises number 32. So these are not the same. North is not the same. No, we have to plan. We have to visually. We need an advocate commissioner for that, and has to go to the site and
on that plan.
7-Eleven cannot.
A decree has been passed on that plan.
Maybe.
And the decree, in fact, gives the boundaries.
The plan is not a part of the decree. Plan is referred to in the schedule.
No, plan is part of the decree.
As delineated in plan on map.
Yes, plan is part of the decree.
Visually, we cannot say. We are not engineers. Even you can't say exactly. You cannot vouchsafe that the two properties are the exact same. The two plans are before us. These are sketch plans, sort of. These might not be drawn to scale even.
Millard, Millard, then that would what will happen is Millard, Millard, even if he says, suppose Millard, for example, Millard, he says purposely to keep my property involved in a litigation.
If exactly the boundaries were exactly identical and the description was same, only the number was different, you would have a good case on 7-Eleven. But if that is not so, actually the conversion rates have you got? Bigha to this square meter.
Millard, kindly Millard take the decree. Kindly take the decree once, Millard.
Let's see. Yes, you're having the decree.
Because Millard, my predicament is this, Millard, from 1985, after having contested with this gentleman and getting a declaration.
Yes.
This frivolous suit will keep me involved for another 50 years.
Absolutely understood.
So that's the reason, Millard, I am trying.
That's why you are hearing it, because if we can reject the plaint you should reject the plaint at the outset, we will.
So that's the reason, Millard. So
we have to be absolutely sure then on the plaint that these two are exactly identical. Otherwise, it will be a tall order in 7-Eleven.
That's what I'm trying to do, Millard.
7-Eleven, it will be a tall order. That is what we are thinking. And because the reasoning of the learned trial judge has gone awry on some other premises.
পেপারে দুটো ম্যাপ ফেলে আনবো পরের দিন
এই ম্যাপটা ফেলে কি করে
একটার উপর দুটো ট্রেসিং পেপারের উপর বানিয়ে ফেলে দেবো
This
দেখা যায় but সেটা চর্চা করবে evidence.
No, but the previous decree, the decree you have handed over, that does not tally with the copy of the
আনঅ্যামেন্ডেড প্লেনটা লাগানো না মানে
No, you have given this, it carries the plaint.
I'm given that.
This is the amended plaint.
Maybe Lord, we have handed over.
This has been handed over by you.
Yes, not me.
If this is the amended plaint, but then the decree B does not tally with this amended plaint. See the decree? This, because it has been scored through, then it might be the amended plaint. If you just look at this does not tally. You just take up, Mr. You take my copy, and I'll take back this copy from you, because I have just please check up the schedule of that, the decree schedule and the amended plaint.
Decree schedule, premises number 30.
See the second boundary, 32A scored through and made 32A, but the decree still contains the unamended.
No, East 32A. 32A.
32A East 32A.
Is the 32A.
What was 32 has been scored and amended plain contains 32A and the decree on the East 32A.
Oh, it has been made. And this tallies with that plaint.
Yes.
That further.
That's amended plain.
Page 72.
That is how 32A. That's what I was trying to show. How 32A came in.
Yes.
So there is no other apart from 32A. There is no other.
Yes. 32 there is a difference, and north also there is a difference.
No, madam.
নর্থে একটা শুধু এক লাইন ঢুকেছে
কোনটা দেখা না
The present suit property north is Raja Santosh Rai Road, the road itself, and portions of 30 Santosh Rai Road. And yours is north is premises number 30 Santosh Rai Road, not portions, entire 30 and remaining part of premises number 32.
Yes, same. Your lordship.
32, remaining part of 32 is not Raja Santosh Rai Road.
No, Santosh Rai Road on the north,
Yes.
south, east, west is the plaintiff's land.
Yes.
On the north, Raja Santosh Rai Road
Yes.
and premises number 30, Raja Santosh Road.
The map X has been, do you have a copy of X?
X. Judge Sahib dilen jeta.
One minute, X. Do you have a copy of that X?
Yes.
You and I are sharing these copies. How can
That is in the
Does the junior have a copy of this, or this is the only?
both the copies have been handed over to you.
তাহলে একটা তো লাগবে।
No, my lord, your
No, no, no,
lordship, kindly, my lord, your lordship.
Do you have a copy, Mr. Bamranji? You have a copy of that entire plane? This is X.
Page 64 আছে can what?
Page 64 of Millard.
But even the area your lordship's query, my lord, we found out, my lord, it is 18 cutters for us.
And plus
Common passage. And there is, my lord, 23 cutters or something like that according to their decree.
Theirs is 1 bigha, 1 kata, 5 kata.
1 bigha is 20 cutters and
20 cutters, yes.
21 kata. Or 18 kata.
Yes.
So essentially,
three cutters here and there.
Yes, common passage is there.
My deed.
And then again, Lord, I can rely upon my purchase deed. Lord, if you, I don't want your lordship, Lord, to go into all this, Lord, and find out. This is a question of evidence. Has to be dealt with by somebody who has to, Lord, examine. I have my, Lord, the deed plan.
Page 50.
At page 50.
I also will not want that whatever I have been declared to be the owner, my lord.
সেইটা বলেছে যে ওই সুটটা বিচার হবে না।
That, my lord, should not be reopened, and I should not be vexed twice for that declaration which I have already got.
এইটুকু হলেই হবে।
That, Lord, my learned friend, Lord, it is the scope is only Order 7, Rule 11. Either the plane remains or it goes. There's no in between.
সেখানে তো আপত্তি থাকার কথা না।
সেটাতে আপত্তি থাকবে
না, মানে আদার সাইডে তো আপত্তি থাকার কথা না।
এসব তো বলতে প্লেন্টিস বাইন্ডিং।
এই সুটে আমার ডিগ্রি
opposing my prayer, then in the plain the decree is binding. How can you say?
Okay.
The suit to সবাই খুশি হবে।
আমি ক্লোজ করে দিচ্ছি 3-4 তারিখে বসে বসে লিখবো কাজ থাকবে।
কি না খুশি।
We let this judgment on 3rd and 4th of March. With some work also during that.
Third and 4th.
এবার কি ট্রেসিং পেপার করে আসবো? বলো না।
Yes.
That evidence. He wants me lord to put one after the other on a trace paper and see it. Show your lord.
That is only left in order 7 will.
Don't do it. The schedules will cover. Because
tracing paper won't help you because that would scales are different.
No, it doesn't matter. All I'm trying to understand is this, Millard, as I started by saying, if I am been declared a specific portion in my decree,
No,
any right claimed within that, Millard,
there cannot be any doubt on that. The doubt is whether.
But he is claiming within that. His boundaries may be here, but he is claiming within that decree.
Question is whether that can be said straight away on a bare perusal of the plaint and the documents annexed there too, or we have to enter into some comparison. If some comparison is necessary, then we require a local investigation at the ground level.
But
and including a comparison with their purchase deed, which they also rely on. Yes. At this stage, it would be difficult.
But my lord, comparison of title deeds or purchase deeds, whatever it is, my lord,
Yes.
is not what they are putting forward. They are putting forward the plate and the decree. At this stage, my lord, I am also relying on, if I given an opportunity, I will also have to again revisit, again show all those documents on the basis of which I got a ticket.
Make the lawyers happy.
No, I can understand, but my lord, thing is,
No, no, definitely.
frivolous litigation, my lord,
If it's frivolous,
is something which, had it been a
but
litigation.
unless we are sure, we'll look into the papers again. Unless we are 100% sure, Mr. Dutt, we'll have to relegate it to trial. At least this issue may be the first issue. Not even a preliminary issue because this is a mixed question. We cannot invoke Order 14 rule to the first part.
Let's see.
We will just try to. Well, the hearing is concluded. The matter is reserved for judgment.
Okay.
Great. Thank you very much. এইভাবে কোনো একটা একটু ফাঁকা ফাঁকা দিয়ে পাঠিয়ে ভুল করেছি
In the passing, kindly will not also consider section 12 of the civil code.
we'll just take ওনার ফাইলটা রাখবে দিন ও কি হবে এটা Section 12, why are you relying on that? Just
Because
elaborate.
it says that is a cause of action between the same party.
Section 12 of CPC. Yes.
So that would bring in the question whether so, Milord, it says, Milord, whether a plaintiff, where a plaintiff is precluded by rules from instituting a further suit in respect of any particular cause of action, he shall not be entitled to institute a suit in respect of such cause of action in any court to which this code applies.
That is a corollary of 11.
Of 11,
yes,
which gives finality, Milord.
Yes, yes. It's supplementary to 11, rather.
Though, Milord, not in here, but it's a question of public policy. That
No,
finally.
definitely, definitely. Only question which we have to look into is whether beyond doubt we can say that yes, on a plain glance, yes.
Or
that is the difficulty. Otherwise, yes, we accept your point because that point was not, I mean, discussed as such by the learned trial judge. In an oblique manner, one sentence was stated that it cannot be vexed twice or something like that.
Yes, but in the plaintiff he says that this dispute in the.
But the learned trial judge goes on some other tangential thing.
That will.
So that's why you have heard you on this only on that because if you are right, otherwise we can find it out from the bare glance of the plaintiff. Then yes.
Because
but apparently no. So that's why
very well.
We'll again look into it. That's why you are taking some time. We'll look into it. If it seems that you are right, I mean.
Because he says that the boundary dispute is settled in the previous.
Admits boundary dispute settled. Everything else is admitted. Both sides are bound.
Let's see.
Much obliged.
Item number 6.
Meeting.
Yes. This matter, I am for the petitioner, my lord. I am the petitioner respondent.
Your suit was dismissed. Divorce suit was dismissed.
I filed the divorce suit that was decreed, my lord. But the person, I filed the suit, my lord.
So why have you preferred an appeal?
No, I have not filed. I am the respondent.
The respondent.
I am the respondent petitioner.
They want expeditious hearing of the appeal.
Due to the girl is the age about 27 years.
This is your application?
Yes, my application. The girl's application, my lord. Last 8 years, she is facing the trial.
So you want to prepare the paper book?
Yes, my lord. My lord, kindly, due to these proceedings, last 8 years.
Have you given a copy to the other side?
Your lordship, kindly.
The matter arises. Are you suffering an order of stay?
No. But
you obtained a divorce decree.
I have obtained the divorce decree.
They have preferred a challenge against it.
But his family member cannot.
So you should have given a copy to the advocate for the appellant.
I'll
supply, my lord. Their appeal will be expedited.
No, my lord. Kindly fix it in 11, my lord. In the meantime, there is a defect, my lord. There is defect in the appeal.
That is their defect. We will take care of that.
Okay.
The appellant, the respondent stroke petitioner shall serve a copy of Can 1 of 2026 on the learned advocate for the appellant stroke opposite party.
To the party, my lord.
No, definitely not. An advocate has filed an appeal and you will give direct to the party. Definitely not. Don't embarrass your colleague. Their appearing in the matter will serve directly on the party. On the learned advocate for the appellant stroke opposite party, indicating that the matter shall next be listed on 2nd March.
My 11th, my lord.
No, 2nd March.
My sister's marriage is fixed
on March 11, 2026, when a receipt in that regard shall be filed by the respondent stroke petition.
Yes, my lord. आपको फाइल तो देवें ना address तो